Good morning, everybody. Trying to figure out where this stuff is from just Judge Wolf. Because he doesn't organize stuff too well. Yeah. So, guys, I'm trying to find this, and I do not see it. It's actually Joseph Daniels. Sorry. Hey, guys. So yeah, I've been looking. This judge that records all his stuff. I don't see it on his YouTube page. So I think I'm gonna have to do what's done online. I gotta figure out. Looks like Law and Crime has it. Sadly, we'll have to use theirs. This is 9 months ago too. Holy cow! Joseph Daniels hearing and trial. Okay. Here we go. Found it. I think I found it. All right. All right, you guys. Have it now. So Joseph Daniels is accused of murdering his autistic son, Joe Clyde. He was charged with the murder. His mom was charged. Krystal was charged with child neglect and abuse. But he's been accused of murder. And I will fill in some information on YouTube. I'll put it in the description. So he's accused of murdering his 5-year-old son in 2018. They never found the body. So this is in Dickinson County, Tennessee, by the way.
Must have proven. Defendant unlawfully killed the alleged victim, Joe Clyde Daniels, that the defendant acted intentionally and that the killing was premeditated. The defendant is charged in count 2 in the indictment with first-degree murder and perpetration of a felony. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant unlawfully killed the alleged victim, Joe Clyde Daniels, that the killing was committed in the perpetration of or the attempt to perpetrate aggravated child abuse, that the killing was closely connected to the alleged aggravated child abuse and was not a separate, distinct, and independent event, and the defendant intended to commit the alleged aggravated child abuse. The defendant is charged in count 3 in the indictment with aggravated child abuse. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury and that the act of abuse resulted in serious bodily injury to the child. The defendant is charged in count 4 in the indictment with initiating a false report or statement to law enforcement officer.
All right, well,
for you to find the defendant guilty.
Judge Wolf's website does not have this. I can't find it on his YouTube channel. So I tried looking, so I gotta use Law and Crime and their crap for now till we can figure this out. So I'm gonna put this on play, you guys, and I'm gonna let it go. I think this one, since it's already been tried, I don't really necessarily know how much to commentate on. But if you guys have questions about stuff, leave a comment or an email, and I'll try to pick up as I go. But yeah, we're just going to kind of catch up till we get to ready for his mom's trial, which I think will be interesting. So here we go, guys.
The state must have proven beyond a reasonable doubt that the defendant initiated a report or statement to a law enforcement officer concerning an offense or incident, that the defendant knew the information relating to the offense reported was false, and that the defendant knew the offense or incident reported did not occur. The defendant is charged in count 5 in the indictment with tampering with evidence. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant knew an investigation or official proceeding was in progress, that the defendant destroyed or concealed evidence with the intent to impair its availability as evidence in the investigation or official proceeding. The defendant has pled not guilty to the charges in the indictment.
I know the judge might be a little loud, but
he is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, an attorney for the defendant may make an opening statement if they should so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dixon County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you have heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and to help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you are to use in reaching your verdict. After you hear my instructions, the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law in my instructions to the facts, and from that application, you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence, to have his attorney make any statements or arguments, or to produce any evidence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. You as jurors must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the indictment. You must base that decision only on the evidence in the case and my instructions about the law. Witnesses will testify in response to questions from the attorneys. Witnesses are first asked questions by the party who calls the witness to testify, and then the other side is permitted to cross-examine the witnesses. Although evidence is presented by asking questions, the questions themselves are not evidence. An insinuation contained in a question is not evidence. You should consider a question only as it gives meaning to the witness's answer. In addition, members of the jury may ask questions of the witness if desired. The procedure for a juror to ask a question of the witness is that the question must be written down and submitted to me. Do not put your name on the question, as the questions for the jury are required to be anonymous. If a juror has a question that he or she would like to have asked of a witness, that question must be submitted in writing while the witness remains on the witness stand. At the end of the witness's testimony, the jury will be excused and I will consider the questions of the jury on the record. Then the jury will return to the courtroom. If the question is allowed by the rules of evidence, the question will be asked either by me or by one of the lawyers. You should not place any significance upon the fact that I asked the question of the witness or whether one of the lawyers asked the question. In either event, the question is being asked of the witness solely because it was desired by a juror. The wording of the question may be altered by me, or the question may not be asked at all. If the question is altered by me, you must assume that I had a valid legal reason for altering it, and you should place no significance upon this fact, nor should you draw any inference from it. I may refuse to ask the question at all. In that case, you likewise should place no significance upon this fact, nor should you draw any inference from it. Many times our rules of evidence do not allow certain questions to be asked, even if both sides desire to do so. After the trial, if you wish to know the answer to your question or the reason it could not be asked, please approach the bench after court is adjourned and I will attempt to explain it to you. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have a particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness have any motive, bias, or prejudice that would influence the witness's testimony? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Was the witness distracted in any way? How did the witness look and act while testifying? Was the witness making an honest effort to tell the truth, or did the witness evade questions? Did a witness's testimony differ from the testimony of other witnesses? Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. As the sole judges of the facts, you must determine which of the witness's testimony you accept, what weight you attach to it, and what inferences you will draw from it. The law does not, however, require you to accept all of the evidence. In deciding what evidence you will accept, you must make your own evaluation of the testimony given by each of the witnesses and determine the weight you will give to that testimony. You must decide which witnesses you believe and how important you think their testimony is. You're not required to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding what testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules to use in deciding whether you believe a witness. In making up your mind and reaching a verdict, do not base any decisions on the fact that there are more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. In deciding this case, you may not draw any inference from an unanswered question, and you may not consider testimony that you're instructed to disregard. Any arguments about objections or motions are usually required to be made by the attorneys out of the hearing of the jury. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or motion will be based solely upon the law. You must not infer from a ruling that I hold any view or opinion for or against any party in this lawsuit. Some of you have probably heard the terms circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in the law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw, heard, or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw, heard, or otherwise sensed, they presented direct evidence. Circumstantial evidence is all of the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided with a paper and pen if you decide to take notes. During the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk with them about any subject whatsoever. You may see them in a hallway or on an elevator at some other location. If you do, perhaps the best standing rule is not to say anything. Do not permit any other person to discuss this case in your presence. If anyone does attempt to do so, report this fact to the court immediately without discussing the incident with any of the other jurors. You also should not discuss this case among yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all of the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. You must not communicate with or provide any information, photographs, or video to anyone by any means about this case. You must not use any electronic device or media such as a telephone, cell phone, smartphone, or computer, the internet, any text or instant messaging service, or any chat room, blog, or websites such as Facebook, MySpace, LinkedIn, YouTube, Instagram, Snapchat, or Twitter, to communicate with anyone or to conduct any research about this case. During the course of the trial, there's a possibility, in this case more than a possibility, that there will be media reports in the newspapers, on TV, or on the radio about this particular case. If there are, you are not permitted to read, watch, or listen to those reports. You as the jurors must base your decision solely on the evidence you hear in the courtroom. You will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not conduct your own private investigation into this case, although you may be tempted to do so. Do not read any textbooks or articles concerning any issue in this case, or consult any other source of information. If you were to do that, you would be getting information that is not evidence. You must decide this case only on the evidence the law presented to you during the trial. Any juror who receives any information about this case other than that presented at trial must notify the court immediately. There are several rules concerning your conduct during the trial and during recesses that you should keep in mind. You will be a sequestered jury. You will not be allowed to communicate with anyone other than your fellow jurors and your sworn jury guards during the entire time that you serve on this jury. You will be kept together as a jury and separated from everyone else. You must not be outside of the presence and supervision of your jury guards at any time other than when in your room. You must not speak to anyone other than your fellow jurors or guards at any time about any subject whatsoever. Second, do not discuss this case among yourselves during the trial. You must keep an open mind until you have heard all of the evidence, the attorney's closing arguments, and my final instructions concerning the law. Any discussions before the conclusion of the case would be premature and improper. Third, obey all instructions from your jury guards. They have been thoroughly instructed as to the proper procedure that must be followed. If they ask you to do something, there is a reason for it. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss the matter out of your presence. I will try to avoid as many of these interruptions as possible. We will try to resolve some of these things in the morning before we get started. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they save time for all of us. If anyone needs a break at any time, please do not hesitate to ask. Simply raise your hand. If I do not see you, get the attention of one of your bailiffs who will advise me that a juror needs a break. Normally, I will try to conclude the testimony of a witness before taking a break. The usual break times are at 10:30 in the morning and 2:30 in the afternoon, with a normal hour between 12 and 1 for lunch. If you need a break at any other time, please ask. A juror who is distracted is not paying full attention to the testimony. Both parties are entitled to your full, undivided attention to the case. This completes my opening comments to you. The next phase of the trial is the formal reading to you of the indictment in this case. This is the third day of June, 2020, David Wolf, Circuit Judge, Division 1. Mr. Crouch.
The grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths present that on or about April the 4th of 2018 in Dixon County, Tennessee, and prior to the finding of this indictment, Joseph Ray Daniels then and there did unlawfully, intentionally, and with premeditation kill Joe Clyde Daniels in violation of TCA 3913-202. Count 2, the grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths present that on or about April 4th, 2018 in Dixon County, Tennessee, and upon prior finding of this presentment, Joseph Ray Daniels then and there did unlawfully kill Joe Clyde Daniels in the perpetration or attempt to perpetrate aggravated child abuse in violation of TCA 3913-202. Count 3, the grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths present that on or about April the 4th of 2018 in Dixon County, Tennessee, and prior to the finding of this presentment, Joseph Ray Daniels then and there did unlawfully, knowingly, other than by accidental means, treat Joe Clyde Daniels, a child under the age of 8, in such a manner as to inflict injury, and the act of abuse resulted in serious bodily injury to Joe Clyde Daniels in violation of Tennessee Code Annotated 3915-402. Count 4, the grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths present that on or about April 4th, 2018 in Dixon County, Tennessee, and prior to the finding of this presentment, Joseph Ray Daniels then and there did unlawfully initiate a report or statement to law enforcement officers, to wit, a 911 call center concerning an offense or incident that the offense or incident reported did not occur, and information relating to the offense reported is false in violation of TCA 3916-502. Count 5, the grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths present that on or about April the 4th, 2018 in Dixon County, Tennessee, and upon and prior to the finding of the presentment, Joseph Ray Daniels then and there did unlawfully, and knowing that an investigation or official proceeding is in progress, did destroy or conceal evidence with intent to impair its availability as evidence in the investigation or official proceeding in violation of TCA 3916-503.
To that indictment, has the defendant pleaded?
Not guilty.
All right, not guilty. A plea has been entered. At this point, ladies and gentlemen, it would be appropriate for either side to make an opening statement if they wish. The state would go first. The state wish to make an opening statement.
Yes.
All right, you may address the jury.
Ladies and gentlemen, welcome to Dickson County. Thank you for being here and thank you for your attention. I want to again introduce quickly the folks that are sitting at the state's table. To my left is Assistant DA Josh Turnbow, TBI Investigator Zach Burkhart, TBI Special Agent Joe Craig, and behind me, Criminal Investigator Josh Etheridge, who will be helping present some of our electrical and digital components. Joe Clyde Daniels. You're going to hear that name a lot. April 4th of 2018, Joe Clyde Daniels was 5 years old. You're going to see a video, probably the last video of Joe Clyde Daniels alive, from April the 3rd of 2018, when he gets off the school bus at the end of the day. He exits with his older brother, Alex, who was 8 years old at the time. They get off the school bus. Their Aunt Joyce is waiting to greet them at the end of the driveway. And that's the last time we have evidence of him being alive on photograph or video. You're going to see proof that Joe Clyde was an active young boy. He loved going to school. He went to school at Centennial Elementary in Dixon. Joe Clyde loved his cowboy boots and he loved his plaid button-up shirts, and you're going to see those. Joe Clyde loved playing with his friends at schools, and he loved the one-on-one interaction from his school teachers. You're going to hear evidence that Joe Clyde loved to eat apples. And that sounds weird right now, but you'll understand as the trial goes along. You're going to hear that Joe Clyde did not like certain things, specifically loud noises, thunder. Those loud noises, chaos, they scared him. You're going to hear from Joe Clyde's teacher. You're going to hear from his speech pathologist that he was a great kid, that he was not difficult, he was not frustrating, and he didn't display very many negative behaviors at all. You're going to hear different stories as to the levels and abilities and disabilities of Joe Clyde. You're going to hear him referred to as having autism. You're going to hear the phrase global developmental disabilities. Essentially, you're going to hear that Joe Clyde Daniels had some learning delays. He was developmentally delayed. But Joe Clyde was able to communicate. He communicated by looking at you with eye contact, by pointing, by making gestures. And he was developing a better vocabulary. You're going to also hear evidence that Joe Clyde was very much lacking in his gross and fine motor skills. In fact, Joe Clyde ranked in the first percentile of classmates his age, the first percentile in gross motor skills. He had weak intrinsic hand muscles. He had problems separating and isolating and using his fingers. He had a hard time pulling out pegs, flipping pegs, opening items. He had a hard time using zippers, buttoning his shirt. He couldn't tie his shoes. At the time Joe Clyde was murdered, he lived in a household with 8 people. His brother Alex, as I've already referred to, who was 8 years old at the time. His brother Noah, who was 3 years old. His mother, Krystal Daniels, who, as you know, is also a defendant charged, but her trial is separate. This is not the trial of Krystal Daniels, but of Joseph Daniels. The defendant, who was married to Krystal Daniels, also lived in this residence. And this is where you have to be careful not to get the names confused. Joseph Daniels Jr., or Big Joe, grandpa, was Joe Clyde Daniels' grandfather. So in the house, you had 3 Joes: grandfather, father, which is the defendant, and Joe Clyde Daniels, 5 years old. Also in the residence was Belle Daniels, who was married to Big Joe, the grandfather, and the aunt Joyce Austin. All 8 of these folks lived in a residence at 1222 Corners Creek Road in Dixon County. Just for some brief context as to the residence, Big Joe, the defendant's father, was the only person that was currently employed. And you will see that he was an over-the-road truck driver that did a long-haul drive from Tennessee to Texas and back. Belle Daniels, Big Joe's wife, was unemployed. Aunt Joyce was unemployed, and you're going to see that she has some hearing and speech difficulties as well. Krystal Daniels, the mother of Joe Clyde, unemployed. You're going to see that the defendant had quit his job in February of 2018 and was also unemployed. For some more background about the defendant and evidence that the state intends to prove at trial, he graduated, the defendant did, from Dixon County High School. He went on to attend college. He majored in computer information technology, and he earned a microcomputer specialist degree from Tennessee College of Applied Technology in 2012. At Nashville State Community College, he majored in computer sciences and computer networking technology. The defendant had recently held several jobs, his most recent being at a company here locally in Dixon called Logical LLC. He was a computer engineer and technician. The defendant has authored at least one sci-fi novel, a fiction work, that was found on his computer after executing a search warrant. This is not a dumb person. The defendant, you will see, has many faces. You're going to hear evidence of infidelity between the defendant and his wife. The co-defendant, Krystal Daniels, was cheating on him. You will see that on the night of April 3rd, the defendant and Krystal Daniels were in an argument over infidelity. You're going to hear evidence that Krystal Daniels was planning on leaving Joseph Daniels. You will even hear evidence that the defendant didn't think that Joe Clyde Daniels was his biological son. And you're going to see from a computer extraction evidence that he was searching on how to conduct paternity testing. You're going to hear evidence that the defendant referred to his deceased son as that boy. You're going to see evidence that the defendant had trouble controlling his temper. You're going to hear evidence likely that he had some mental health issues, although these are not an excuse for his actions. You will hear evidence that the defendant, during some of his evaluation, showed tendencies to malinger. Now, for those of you that don't know what malingering or malinger is, it's the intentional production of false or grossly exaggerated physical or psychological symptoms, motivated by external incentives such as avoiding military duty, avoiding work, obtaining financial compensation, evading criminal prosecution, or obtaining drugs. That's what malingering is. Now, on the night of April 3rd, 2018, it's important to note that the grandfather, Big Joe, and Belle were out of the state. They were on a long drive in his routine drive to Texas. Now, it's a round trip drive, but they go to Texas and back. They were out of the state of Tennessee. In the residence on the night of April 3rd, 3 adults, Joseph Daniels, Krystal Daniels, and Joyce Austin, the aunt. 3 children, Alex, Noah, and Joe Clyde. On this particular evening, Noah was sleeping in a bedroom alone with Aunt Joyce. You're going to see that Alex and Joe Clyde Daniels were sleeping in the master bedroom that would normally be occupied by Big Joe and Belle. But since they were out of town, Alex and Joe Clyde slept in that room. The defendant and his wife, Krystal, were sleeping in their own bedroom. You will also hear and see proof that on this night it was raining outside with thunderstorms that were widely scattered across Middle Tennessee. You're going to hear a series of stories directly from the defendant. According to the defendant, on the night of April 3rd, At about 11:30 p.m., Joe Clyde got out of bed. Remember, he's in Big Joe and Belle's bedroom and urinated in the floor. And apparently this was not uncommon behavior from Joe Clyde. Upon that occurring, the defendant got out of bed, and according to him, he puts Joe Clyde back into bed, and he himself returns back to bed, goes to sleep, and he doesn't wake up again until 5:30 a.m. And that's important to note because that's the initial story that he gives. Joe Clyde urinates in the floor. He puts him back to bed about 11:30 p.m. He sleeps until 5:30 a.m. The defendant then claims that he wakes up at 5:30 a.m., goes into the bedroom, and finds that Joe Clyde is gone. He says he searches the house, goes around outside, can't find him, and the search begins. At 6:22 a.m., so roughly 52 minutes after he notices Joe Clyde is missing from the house, he makes a 911 call. On this 911 call, which you will hear, the defendant claims that Joe Clyde escaped. He says, "My son has escaped and we cannot find him. He has autism. Last time he was seen was last night." How did he get out of the house? He was asked on the 911 call, and the defendant says he must have unlocked the door. He describes Joe Clyde as being roughly 48 inches tall and 65 pounds. He's asked how severe is his autism, and he says he has ADHD with it too, pretty significant. He can't talk, unable to communicate. He tries to bathe himself, but we have to bathe him. And you're going to hear this on the 911 call. The defendant's story then kind of progresses as first responders arrive on the scene. What he tells first responders, who are there quickly within 10 minutes of the 911 call, is that in the middle of the night, Joe Clyde goes into the living room and takes the coffee table and moves the coffee table to a door, climbs on top of the coffee table, gets a key off of the mantle over the fireplace, reaches to the top of the door where there's a padlock installed, sticks the key in the padlock, takes the padlock off the latch, returns the key to the top of the mantle, hides the padlock in some toys next to the door, gets off the table, pushes the table back to the center of the living room, exits the door, and closes the door behind him in the middle of a thunderstorm. That's his story to first responders. And ladies and gentlemen, from that story, law enforcement begins one of the largest searches in the history of Middle Tennessee for a missing child. Over 20 emergency services agencies responded to Garners Creek Road almost immediately. You're going to see photo evidence, video evidence, the volume of people that responded, not just emergency services, but citizen volunteers were literally bussed in on that day to do inch by inch, square by square, grid and GPS searches of the entire area. By 8 a.m., the Tennessee Highway Patrol had picked up the first responding deputy on the scene. His name was Sergeant Daniel Baker, and Sergeant Daniel Baker was in a helicopter by 8 a.m. over the area. By noon that day, the Tennessee Bureau of Investigation had dispatched its airplane with infrared cameras that was doing grid by grid searches over the entire Dickson County, Humphreys County area. Numerous canine search and rescue teams were deployed. Rescue divers, submersible cameras were brought in to search nearby ponds. Ponds were drained, completely emptied. The septic tank of the Daniels residence was drained. Hundreds of volunteers. All of these actions and searches took place based on the defendant's 911 call and his initial statements to first responders. Keep in mind, the defendant does give a confession, but it's 2.5 days later. For 2.5 days, based on these lies, the defendant and his wife are free to come and go wherever they want to go, to conceal, to destroy evidence. Free to go. They're not under investigation. They're not under scrutiny. They're not being held. They're free to come and go wherever they want. However, on April 6th, 2.5 days later, at approximately 4:00 p.m., the defendant and his wife voluntarily drove themselves down to the Dixon Police Department, not escorted by police, but voluntarily. Upon arrival, he was Mirandized, and you will see that on video. He was read his rights. He voluntarily engaged in an interview with law enforcement. And this leads to confession 1. And you're going to hear this confession and see it on video. And in it, the defendant states, and you're going to hear, that he admitted to his initial statements to law enforcement were a lie. They were a lie. He admits that he, the defendant, moved the coffee table, that he hid the padlock, that all the story was made up. What defendant says really happened on April the 4th was that he whipped Joe Clyde for urinating in the floor. And that after he whipped him, Joe Clyde got back out of bed and laughed at him. And so he whipped him some more. And then the defendant says that he whipped him again and he was upset. So he put Joe Clyde outside of the house. And then you're going to hear the defendant say that Joe Clyde ran towards the road, Garner's Creek Road. So the defendant goes outside, angry, gets Joe Clyde, brings him back inside, whips him some more, and then slams his body on top of a coffee table.
Your Honor, I request that item be read.
Ladies and gentlemen, you may step across the hallway while I take up the matter, please. All right, Mr. Lockhart. Mr. Mitchell.
Your Honor, in the pretrial motions, the defense filed motions requesting that the state not be allowed to talk about the confession until they had put in evidence to corroborate the confession and make some form of prima facie showing of a crime. And the state's introducing that now after the court has ruled that that would have to wait until they'd had a hearing after putting forward evidence. And we're asking that they not be allowed to talk about the confession until they put on evidence.
Let me hear from the state and their response.
Judge, first of all, as you have just instructed the jury, it's not evidence, it's opening statements. And second, there was never an order put down saying we couldn't discuss it in opening statements. The issue is admissibility of the confession to the jury after we put on corroborating evidence. Second, yesterday in voir dire, the defense spent a lengthy amount of time discussing false confessions. This jury's already aware that there was confession. Let's not be blind. They just don't want me to talk about it. But I'm going to talk about it because that's not the law. Unless Your Honor specifically instructs me to disregard any form of mention of the word confession, I'm going to keep going with it.
First of all, the court did not rule that there could not be some discussion. In fact, in response to Mr. Lockhart, one of his concerns was that if I did not make a definitive ruling on the issue of the admissibility of the confession, both as to voluntariness and trustworthiness, that he would be hamstrung in the jury selection and talking about the confession because it may or may not come in. The court advised at that time that the ruling on the trustworthiness under the modified trustworthiness standard under the Bishop case would be made after the state had put on sufficient corroborating evidence. I ruled that the confession itself would not be admitted until such time as we had had a Bishop hearing and that standard had been met in this court's opinion. Nowhere did I exclude either party from talking about the confession, and Mr. Crouch is right. Yesterday in Chattanooga during voir dire of the jury, a great deal of time was spent on, and in fact, Mr. Lockhart asked the jurors to raise their hand if they agreed that there could be a false confession. And they all unanimously raised their hand that they thought under circumstances there could be. So while the state is, in my opinion, entitled to make its opening statement regarding and talk about what they expect the case to show, Like any other opening statement, the evidence may not bear out what the state is saying. The defense will also be able to talk about a false confession. I assume that would be something that you would address in your opening statement. However, in order to make sure the jury is reminded, when they return, I will instruct them once again that statements of counsel and opening statements are not evidence, and that they will have to wait until such testimony is admitted to them and consider only that testimony that is admitted by the court.
Thank you, Judge. Your Honor, may we have a moment for Mr. Daniels to take his medication? Apparently he has some that he has to take at a certain time, and it's that time.
All right, well, let's do it while the jury's out. All right, Mr. Taylor, anything else before we bring the jury back?
No, Your Honor.
All right, both sides ready for the jury? All right, let's ask the jury to return, please. During the course of this trial, you're going to have many instances where you're going to get up to exercise your legs and walk across that hallway. So I apologize in advance for doing it. As I explained to you, sometimes I have to take up matters outside of your presence, and I did that. I just want to remind you that what I instructed you a moment ago, sometimes it's hard to remember that. What the lawyers, and we have two good lawyers, or I have many good lawyers on both sides of this case, and they're very accomplished orators, and they'll tell you things. You have to remember that what they say, and especially in opening statements, is not evidence. We haven't started the trial with witnesses yet. You decide the case on the witness's testimony and the exhibits that I allow in. And while the lawyers can make their argument, it is not evidence. Both lawyers may tell you what they think the proof is going to be. It may or may not turn out to be that when the trial is concluded. You may say, well, they didn't prove this or that, even though they said that. So that's up to the lawyers as what they think their case is going to involve and what they think is going to be admitted as evidence. Both sides have the right to state their position on that. But that statement by the lawyers is not evidence. So does everyone understand that? All right, with that admonition, then I'm going to allow Mr. Crouch to continue.
Let me make one clarification before we move on. When Judge Wolf refers to the good orator and good lawyer, he's talking about Assistant Josh Turnbow, not me. So, all right, back to the confession, the initial confession made by the defendant on April the 6th. First confession number one. The defendant admitted to police that Joe Clyde did not push the coffee table to the door and escape. He admits to police that he killed Joe Clyde. The defendant also says, when I get angry, things happen. And we're going to prove to you that night that he did get angry and things did happen. The murder of Joe Clyde Daniels. The defendant specifically tells investigators that he did not stop hitting Joe Clyde until he realized he had lost control. The defendant also tells investigators that Alex, age 8, saw everything. The defendant admits that he threatened to kill Alex should Alex disclose what he saw. The defendant describes to investigators exactly what he was wearing when he committed the murder. Red gym shorts, a black shirt with an alien wearing a Santa cap, and the text, "I believe." It just so happens that in the destruction of some of the evidence, that shirt was washed and it was recovered by the TBI, as you will see, out of the laundry in the defendant's home. On the night of April 6th, the defendant agreed to take law enforcement to the location in which he had concealed Joe Clyde's body. You're going to see that that was a lie and that the defendant never intended to disclose the location or what exactly he did to Joe Clyde's body. In a car ride from the police department to McElhaney Road, which is near the defendant's residence, you're going to hear the defendant say, unsolicited, you're going to hear him say, "I want all the monies that have been donated from 2 days of searching, volunteers, donations being made. I want these monies donated to pay for Joe Clyde's funeral expenses." His body is not found that night. As you will see, it's never been found because the defendant has continued to conceal the location. The proof is going to show that the following morning on April the 7th, the defendant admits to law enforcement that he lied about the location of the body. He didn't lie about killing Joe Clyde, but lied about the location of where he concealed the body. He then signs, after being Mirandized, a written confession saying that he killed Joe Clyde. The defendant is then taken to jail, and later that day, after several hours, he initiates a phone call. Not law enforcement, but the defendant makes a phone call to law enforcement and says he wants to provide some additional details. And what he tells law enforcement is that he had discarded the body by placing it in the trunk of the car, that he had driven to a truck stop approximately 9 miles away from his house. He stopped at the truck stop. The Joe Clyde's body was in the trunk of the car. He went into Love's, bought something, and then took the body and threw it off of a bridge into some water. That's the third confession. They get the defendant out of the jail at his request and take him to multiple bridges to see if he can show them exactly which one. And he continues to lie. The defendant is then driven back over to the command center, which is still up and running. And it just so happens that Big Joe, the defendant's father, is back in town from his long haul drive. A TBI agent, Brant Holt, allows the defendant's father, Big Joe, to get in the vehicle with the defendant. And in the vehicle, the defendant tells his father, "I beat Joe Clyde." Not coerced. "I beat Joe Clyde." Tells his own father that. I want you to step aside from what I've just been talking about, as our proof will be of these confessions. And when the proof goes down starting this afternoon and throughout the rest of the time, please pay special attention to the defendant's movements away from the house beginning in the early morning hours of April 4th, 2018. What you're going to see when this search starts is that the initial responders go to the defendant's house and they try to take some initial questions from both parents. Demographic type questions, very specific questions to help them, define these search grids. He leaves. You're going to see proof that the defendant, as the wife is being asked these questions, gets in his car and leaves. And he drives around the neighborhood, not once, not twice, 3 times. And you're going to see through GPS locations that the defendant, where does he drive? 9 miles away to Love's. And then back, and he returns to the house. And when he gets back to the house, he makes one request of law enforcement: check my trunk, the trunk of his car. The proof is going to show that these confessions were voluntarily made, that they were not coerced in any way. In fact, the last 2 confessions came about from the defendant calling law enforcement, as far from coercion as you can possibly get. Yesterday, I asked number one question for you to follow the law, and I'm asking that same question again of you today. You're from Hamilton County. This is Dixon County. I wore my Tennessee flag today because we're all citizens of the state of Tennessee under the same law. We carry the burden of proof in this trial. Hold us to that burden. Make us prove this case beyond a reasonable doubt. But when we conclude and you go to deliberate, do not reward the defendant for being successful at destroying evidence and concealing a body. Thank you.
Ladies and gentlemen, an opening statement is an opportunity for both sides to kind of lay out what they think the proof is going to show. It's kind of like a map that can help you as you go through this trial, see where this case is going. And obviously, we disagree with the state on what we think the evidence is going to show. But you will hear testimony and proof that when our client, after he had contacted police, he told them that he had got up that morning, got Joe Clyde Daniels' clothing for school and Alex's clothing for school, laid them on the coffee table, and then went to see, to wake the boys up. When he got in there, Joe Clyde Daniels was not present. He drove around and looked some. He even took the brother Alex to drive around and look. He called his father and then called 911. And you will see that that's what Mr. Daniels told law enforcement when he came in to be questioned. He told them over and over again, that's what happened. But law enforcement would not accept that answer. And they continued to accuse him of lying, that you've got to tell us what happened, what law enforcement wanted. The truth they wanted was for our client to say he did something to Joe Clyde. But 20-something times he tells them, I didn't do anything. They stay on him and stay on him in that questioning and tell him essentially, we're not going to stop until you tell us what we want to hear. And they go hours. And eventually, the TBI and law enforcement start giving him information that he can use to say he did something. So they tell him that they know someone left the house. They tell him that they know someone took Joe Clyde Daniels from the house. They start feeding him the information. And as you watch the confession, you can see him gradually start realizing, I'm going to have to tell them what they want to hear if this is going to be over. Keep in mind, my client's mentally ill. And so you can see in his face, he gradually starts realizing, and at first he thinks he's in trouble because they forgot to lock the door. And so he tells them that Joe Clyde scooted the coffee table over and took the lock off the latch. It's possible that he scooted the coffee table over. And we don't contend that he had the motor dexterity to unlock the lock. We do contend that he would have been able to take an unlocked lock off the latch and just lift it out. But you'll see that was not enough. So they stayed on him, and then he moved to saying, well, I took it off and I put him outside. And then I went out and got him, brought him back in, and I spanked him more. And at first he tells them he did pee in the floor, and I just told him to get back in bed. But that wasn't enough for law enforcement. They wanted something more. So TBI agent Joey Boyd, and he can explain to you why he said it, but he told him if it's him, he would have whooped their ass too. So he's telling him, say you was mad, say you whipped his ass, say you beat him. That's what Agent Boyd's trying to get him to say. And so they keep going, and he goes a little further and says, okay, yeah, I whipped him hard. And Agent Boyd will tell him how many times you hit him. Wasn't it more than a few, or wasn't it this? Yeah. And wouldn't you say that you were pissed off? Yeah. He says, yeah, I was pissed off. He just gradually adopts what they're telling him into his statement. They keep on him, and finally, Agent Boyd points to the door and says, you tell us the truth, which means the truth they wanted, you'll walk right out that door. You're going to leave here. And my mentally ill client believed, well, I'll just tell them what they want to hear. And then I get to leave. I get to walk out that door. So he did. He told them that he beat Joe Clyde Daniels 15 to 20 minutes in the living room on the coffee table. That he, our client with a black belt in karate who weighed 282 pounds, beat him for 15 to 20 minutes, opened the wound on his head. Blood was running down both sides of his face. Blood was on his leg where he threw him into the coffee table. He starts giving the agents what they want. But still, they're having trouble getting specifics out of him. And at one point, the TBI agent, Faulkner, asked him, are you remembering what's happening? Or are you making this up? I mean, you're not making this up, right? So even the TBI agent realizes that he's making stuff up and ask him, you're not making this up, right? That agent was spot on right there. He was making it up. And not long after that, our client tells him, I don't really remember. I'm just speculating what may have happened. So they do get a confession, but I submit to you that it was a false confession. And not just because the agent doubted whether he was telling truth, not just because the agent said, you making this up. That's a great indicator that even the TBI thought he's making it up, but also because what he told them was not borne out by the evidence. You'll see that the forensic scientists went into the house. They cut up carpet to check for stains around the coffee table. They checked the coffee table. They searched the house thoroughly. They searched the vehicle, the trunk of the vehicle. And even though our client had confessed to beating this child 15 to 20 minutes, even though he said there was blood running down both sides of his face, even though all that was said, not one drop of Joe Clyde Daniels' blood was found anywhere in the house, not on the coffee table, not in the carpet. You'll see photos and a video where law enforcement arrived. There's been no forensic cleaning. You don't have areas in the carpet that have been bleached. There's simply no physical evidence that what our client told them is true. Same thing for the car. TBI investigation will then show that the car did not leave the house. Our client said that he killed Joe Clyde Daniels. He carried his unwrapped body out, put it in the trunk of the car, left and took the body off McElhaney Road, walked out in a field in shorts using his wife's cell phone as a flashlight, then came back home and got in bed right around midnight. Other evidence is going to show you that didn't happen. The TBI, in their own search warrant, admitted that it was not believed that that vehicle left at that time. In fact, they used that in a search warrant because they believe there's probable cause that Joe Clyde Daniels' body is there in the yard at the residence. And so they acknowledge what he told them is not true. He didn't kill him, take him off at 11 or midnight, come back home, get in bed by midnight and go to sleep. That didn't happen. There's no blood evidence of that, no physical evidence of that. They know the car didn't leave because they saw the neighbor's security video, and they made oath in an affidavit for a search warrant that they don't believe the car left and that they think the body's probably in the yard. So they realize that the confession is false, and they're trying to find another way to get evidence against our client. So they bring in crews, and for almost 2 weeks, they've got machines that can sonar or x-ray, whatever, check the ground. They dig holes up. All they find in the yard are some dog bones. So Joe Clyde Daniels is not there. And they know they've got problems with the case because a witness by the name of Daniel McCormick, who was driving home from Belmont University in Nashville at approximately 12:45 in the morning, saw a person he described as a teenager or a smaller teenager or person. He describes this person he sees as wearing a black shirt with a skeleton on the front, either white or glow in the dark. That is exactly what Joe Clyde Daniels was wearing. And the significance of that is, if our client's confession is true, and he had killed this young man and taken the body off, then came back home and got in bed around midnight, then how is this child that he killed and concealed the body standing alive out there in the road? He's not. The state at first, and the TBI acknowledged in testimony, in statements, they acknowledged that that was Joe Clyde Daniels that was seen out there on the side of the road. But that started changing when they realized, put two and two together and realized this child was a third of a mile down the road, which did not corroborate our client's statement. In his confession, he said that he ran out to the end of the driveway, brought Joe Clyde back. So it doesn't corroborate that. And if he's killed him and gotten rid of the body, how's he alive standing on the side of the road at 1:45 in the morning? He can't be. So the state kind of moves from adopting that Mr. McCormick saw the child, and I submit they'll try to convince you now that Mr. McCormick saw our client standing out there in the road. But Mr. McCormick will tell you it was not a grown adult. It was not a man that weighed 282 pounds, and he is certain as to what he saw. So all those things are things you'll look at that will tell you that the confession is not true. Not just because the agent doesn't believe it's true and ask him if he's making it up, but because of the lack of physical evidence. Eyewitness who saw the child alive on the side of the road after my client had said he'd killed him. That's the type proof in this case that will give you reasonable doubt. And you're going to hear that once the state got their quote confession by telling them, if you tell us what we want to hear, you can walk out that door, paraphrasing, they pretty much shut down the investigation. They did do a thorough GPS search for a radius of 6 miles, but they didn't do thorough searches outside that. They received a report from a lady that was approximately a mile away that her 4-year-old's footwear, boots, were taken off her porch that same morning that Joe Clyde went missing. And you would hope that they would take the dogs out there and try to pick up a scent and follow where those boots may have gone. But did they? Nope. They received a report that a young girl at another residence reported seeing a young boy in dirty pajamas. And you would hope that they would go out, take the dogs, try to pick up a scent and follow that to see if they could find this child alive. But they didn't. They drove up and down the road, but they didn't do a thorough search. You'd also hope, based on a report, that other than bringing dogs out there and doing a GPS search, that they would have searched the camper in that yard where a sex offender lived, in the very yard the little girl reported seeing the boy in dirty pajamas. But did they? Nope. They didn't even talk to the next door neighbor, a man who lived in a shed without plumbing. They didn't talk to him until almost 2 years later. And you're going to hear in regard to that, how biased this investigation was. The state did not want evidence that my client confessed falsely. They didn't want to know what happened. So they confront this neighbor with the fact that their video study showed a vehicle leaving his driveway around 5 in the morning. The only vehicle that left either drive before 6. They asked this gentleman to let them have the phone so they could determine his location. Do Google location service and that technical stuff that I don't know about. But they asked him to do that, and they're going to testify that he wouldn't let them have the phone. They will testify that he told them he was concerned there might be information on his phone that would be incriminating. Did the TBI follow up on that? Get a search warrant and check that man's phone to see where he was? No. So I submit to you in this case, you're going to hear that they took a mentally ill person and essentially tricked him into making up a confession that they figured out pretty quickly was not true. No blood evidence to indicate he beat the kid for 15 to 20 minutes in the living room. No blood evidence in the trunk of the car. The car didn't even leave like our client told him he did, because they've got a neighbor's video that shows it didn't. So what does the state do if they can't show he took him in the early morning hours off? Then they have to look and say, well, let's get a search warrant and see if he buried him in the yard. Wasn't in the yard. So what do they do then? Well, man, we're in a bind. Let's say that he called the police out there, and then after the police got there, he drove off with the body in the trunk of the car and got rid of it somewhere. They're going to ask you to believe that if you kill a child, you're going to call the police out there when you still have the body in the trunk of your car. That's the most absurd thing I've ever heard. They don't have a case. They keep trying to change the facts to get to it, and that's what you're going to see in this case. They realize the confession's false, so they dig in the yard. Oh boy, we're going to find him in the yard. Nope, he's not in the yard. Well, let's just say he was in the trunk of the car when the police got there, and that the defendant called the cops and had them come out while he had the body of the deceased victim in the car. All that's going to show to you that the state cannot meet their burden beyond a reasonable doubt. I'll ask you to use your common sense as you listen to the videotape confessions. You will see that they convinced my client that he had killed his child. You will see that they had him so convinced that he was crying and saying, my daddy's going to kill me. You will see that my mentally ill client was convinced that he had killed the child, and so he tried to speculate and make up what he thought would happen. And it sounded good when you first listened to it. Beat him 15 to 20 minutes in the living room, wound on his head running down both sides of his face, wound on his leg from being thrown against the coffee table, takes him off, walks the body out in the field using his wife's cell phone. That sounds good until you start looking at the actual evidence, and you'll hear there's no proof that her cell phone left. There's no proof that his car went there. There's no blood evidence in the vehicle. There's no blood evidence in the house. And you can use your common sense. If y'all ever had a wound to your head or your face, and you know the capillaries in your head and forehead, when it gets busted open, what happens? Use your common sense in this case, and you'll just see that the state keeps changing. At first, yep, he killed him, put him in the trunk of the car and took him off. Well, no, we got problems there because there's no evidence to corroborate that. Well, he buried him in the yard, so let's get a search warrant. Let's get out there and dig 12 days, however many. Mr. Crouch was out there and Mr. Turnbow. They were both out there digging and picking up tree limbs. But that theory wasn't good. They found out he wasn't there. So now they're going to have to come up with something else. And I think based on what state has told you, they're going to try to argue that he had the body deceased in the car And then, of course, it makes good sense. If you're a really smart person, you call the police and have them come out while you have the body in the trunk of your car. It's just absurd. This prosecution is absurd. And I submit at the end of the trial, you'll see there's no evidence. Thank you.
All right, State may call your first witness.
The state calls Jessica Donnerstag. You need some help turning this around, please. We should have Jake's grandson.
Yeah.
You'll step right up here, please, ma'am. You'll face our clerk and raise your right hand and let us take on the oath.
You solemnly swear or affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God. Yes, ma'am.
I'm going to ask you to state your full name and to spell it, the last name for us.
Jessica Donnerstag, Donnerstag.
Good afternoon.
Hi.
That was actually my first question, so we're past that. Ms. Donnerstag, thank you for being here. Would you tell us what your occupation is, please?
I'm a speech language pathologist.
Thank you. And where are you employed?
I'm employed with the Dixon County Board of Education,
Okay. What's your current position with the Dixon County Board of Education?
lead speech language pathologist.
Thank you. Will you tell us some of your educational background as to how you became a pathologist? I'm sorry,
Yes.
speech pathologist.
Yes. I have an associate's degree in logistics from the Community College of the Air Force. I have a bachelor's of science in communication disorders with a minor in special education. And I have a master's degree in speech language pathology.
Thank you. In 2018, were you employed by the Dixon County Board of Education?
Yes, sir.
And what was your position at that point?
As speech language therapist.
Okay. And were you assigned to a particular school?
I was at Centennial Elementary School.
Centennial Elementary.
Yes.
And are you familiar with the name Joe Clyde Daniels?
Yes,
Was Joe Clyde one of your students?
he was.
How long were you Joe Clyde's teacher?
He began, roughly 3 years. There were some breaks in the time that he was coming to our school.
Okay.
So he started out in our 3-year-old preschool class, and he came from August until I believe February. And then he re-enrolled the following year as a 4-year-old preschool in November, and then finished up the school year, and then the following year as a kindergarten student.
Let's talk briefly about his kindergarten year, which would have been the fall of 2017 into the spring of 2018.
Yes.
How many days per week did you work with him that year?
I worked with him at least 3 days a week. Sometimes I saw him more and would, intervene and kind of do some therapy and with other teachers and
Sure.
things like that.
Did you enjoy working with Joe Clyde?
I loved it. He was a really great student.
Can you tell us what type of student he was and how he did?
He was a great student to work with. He was very funny. He was very energetic. He loved to play and he loved to joke around. He he really took instruction well. He enjoyed doing the activities that we were doing, and he made a lot of progress. He had a lot of potential.
Okay. Tell us some of Joe Clyde's likes and dislikes. Start with the likes first.
He loved to eat. We ate a lot in therapy, especially apples, but really anything. He also loved to play games. I saw him individually, and then I also saw him in small groups with other children. And so he really enjoyed interacting with his peers and playing with them.
Did he have any dislikes?
He did. He didn't particularly like really loud noise and a lot of chaos. He was he liked to be neat. He kind of he wasn't really into a lot of the messy play. He kind of, if he had something on his shirt, we wiped it off. He enjoyed kind of a calmer atmosphere, I guess.
Okay. What kind of clothes did he like to wear?
He liked to wear his jeans and a little button-down shirt and his boots.
He liked his boots.
He loved his
Were
boots.
they cowboy boots?
They were kind of yes.
Yeah. Okay.
Little square-toed boots.
Tell us about what role you played with his education.
When Joe came in, I was part of a team that reviewed assessments and helped determine eligibility. That's done as a team with different members that have different roles. And then from there, we develop a plan. And then that plan kind of explains where he's at, and then what we're going to work on, and kind of how we're going to address those goals. And so when he started, I did push-in therapy, where I went into the room and kind of worked with a whole group and did therapy there. And then as he got older, I did more individual sessions and small group sessions.
Okay. When you talked about being on a team that developed a plan for Joe Clyde, what is that plan called?
It's called an individualized education program. A lot of times we call it IEP for short.
And what is an IEP? What is that?
It lays out what we're going to work on. So students that if they've been determined to have an educational disability, then we develop the IEP, and that plan just lets us it guides us. It's an agreement of, these are the goals that we're going to work on. We're going to do it this many times a week. This is who's going to be involved. And then we take data and we track that progress and then adjust it every year.
Does the plan include assessing his current skill levels in different areas?
Yes.
And does this specific plan do so?
Yes.
Okay. Honor, may I approach the witness? Right. Ms. Donnerstad, can you identify this document, please?
So this was his latest IEP. It also has a minutes note and then some evaluations that were done that year as well.
Okay. And Ms. Donnerstag, on the second page, not the title page, but the second page, is that your signature?
It is.
And you, as you've already testified, were one of the team members that developed this plan?
Yes, sir.
And are you familiar with the contents of this plan?
I am.
And I want to spend just a moment going over some of his evaluation, okay?
Yes.
Let's first turn to what's known as the Dixon County Schools Physical Therapy Evaluation, which has listed communication, posture, range of motion, gross motor skills. You see that page?
I do.
In this plan, can you identify what his general communication level was?
At this, it says that he was able to communicate during the evaluation with eye contact, gestures, and pointing. He showed a desire to count but could not articulate any numbers. He tried to say blue and said the word ball during the evaluation.
In this plan, the initial evaluation was in the fall of 2017. Is that correct?
For the physical therapy?
Yes. So, and we read what his communication level was when this plan was submitted. Had he gotten progressively better during the course of the school year?
Yes.
And can you describe for the jury how he progressed?
He aggressed both with his verbalizations and then with his nonverbal communication skills. So when he started out, he really had mainly spoken a lot of vowels with not a lot of variation. And he became where he was kind of varying that. So, counting may have been a ooh, e, where you're not really hearing those consonants, but you are hearing, you can tell that it's a different number. It's not the same sound every time. And then he was also able to say more words. He was able to articulate more, especially familiar words that he used quite often. And then he was also able to do some functional signs to request if, yellow, more, eat, some of those. He also had some picture stimuli or some choice boards that he could identify, or picture cards that he could communicate that way. And then just the back and forth conversation also kept progressing.
Okay, thank you. Let's talk about gross motor for just a moment. What was the summary of his gross motor skills? It's on the bottom of that page.
Of the first one.
Yes, ma'am.
Okay. I'm just going to read
Sure,
this.
please.
Is that okay? Joe was evaluated using the movement ABC for age band 1, which is 4 to 6 years. He was 5 years and 3 months at the time of testing, and therefore tested as a 5-year-old. Joe's scores on this test fell in the first percentile when compared with other children his age. The test has 3 sections: manual dexterity, ball skills, and static and dynamic balance. Joe had difficulty in all sections, but had the most difficulty in the sections that were timed due to his high level of distractibility. I had to give him several reminders to return to task. He had a hard time with catching a beanbag as well as rolling a ball at a target. Upon assessment of Joe's gross motor skills outside of the test given, he demonstrated the ability to jump up, jump forward, jump 3 times in a row, and jump off, but was not able to hop on 1 foot. He was able to walk on a balance beam for 4 steps, walk on his toes, and walk on his heels. Joe ascends the steps with a reciprocal pattern with a rail and descends with a mark time pattern with a rail. He had increased difficulty with ball skills, coordination, and motor planning activities. Joe's run pattern has not quite developed as a mature running pattern at this time. Joe definitely struggled the most with any activity requiring hand-eye coordination, whether that involved fine motor or gross motor activities.
Thank you. Now, first, let me move that as exhibit number 1 in the state's case, Your Honor.
All right, we'll mark that. This is a copy of the individual and educational plan, and we'll mark that as exhibit 1.
Thank you. Ms. Donnerstag, during the school year, did you take individualized notes about Joe's progress and his strengths and weaknesses?
I did.
Can you identify these documents, please?
These are my notes, my personal notes.
Thank you. And there's lots of notes here, but I want to turn your attention specifically to what you have labeled as the alphabet locks. What is an alphabet lock?
An alphabet lock is they're little plastic multicolored locks, and they have a corresponding plastic key. And so there's a letter and a picture on the lock, and then there is a letter, a lowercase letter. And on these, I think we put the uppercase letter as well on the key. And so the target of the task is to match the appropriate lock and key. And if they are a match, then you can put them in and the lock pops open.
Is this what you're referring to?
Yes,
That's an alphabet lock?
it is.
The lock and the key? All right. And is this the type of lock and key that you used with Joe Clyde?
It is.
And you made some specific notes about his performance using the lock and key. What did you say?
I said that alphabet locks could match upper and lowercase letters, had difficult time manipulating key and lock, discussed poor fine motor skills with OT, which is the occupational therapist. Kelly said she was aware and has been working on fine motor skills.
So I believe you actually witnessed Joe Clyde successfully get the lock into the key into the lock. Is that correct?
I did. It was labored. It was a difficult task. The particular task I was actually doing in a group therapy, and there was a marked difference between what he could perform and what his same age peers could perform as well.
Okay. And I will move the lock and key as the collective exhibit.
Exhibit 2, collective.
I'll also move a copy of Ms. Donnerstag's notes as collective exhibit 3.
For the record, we're going to make the lock and key as a collective exhibit number 2, and then the copy of that, what you're saying is exhibit 3.
Yes, these are the handwritten notes of Ms. Donnerstag. Talking about Joe Clyde's motor skills, fine skills, speech skills, you said he was in the 1 percentile. He was markedly different than the other children in how fast he could perform tasks. Is that correct?
Yes.
But what about his ability to do some of these tasks quietly? Was Joe quiet?
He was not quiet. With the fine motors, that's, kind of your small hand movements, and your gross motor are your big movements. And he had difficulty with both of those areas. So when he did something, it typically was kind of loud and wobbly and just kind of overall coordination.
Was Joe in any form or fashion stealthy?
No.
Okay. Now, you also, in documenting your file that you kept on Joe Clyde, took some photographs of him. Is that correct?
I did.
And I'm going to ask you to turn your attention to the screen. Let's see if you can identify some of these photos for us, please. Are these 3 photographs of Joe Clyde that you took?
They are.
And were these photographs taken in your classroom?
They are.
Now, are there other students in the classroom while you're working with Joe Clyde?
On that particular day, I do not believe so. But I did see him. I saw him individually, and I saw him in a group as well.
And can you explain kind of what he's doing in the 3 separate photographs?
In the first one, it's a sorting task, and so there are different Marvel Avengers, and there's a top and bottom, and it's kind of like a memory game where you remove the cup and find the match and put them together. He's kind of really proud of himself in that picture, smiling. In the second one, we completed a puzzle together, and I believe he was pretty happy with himself in that one as well. And then in the third one, we're having a snack, and I think he has a big bite of apple in his mouth.
And are these the shirts that you're referring to that he likes to wear, the button-down plaid?
Yes.
And does this photograph represent what we are seeing on the screen?
Yes, sir.
And I would move this photograph as exhibit number 4.
Yes.
Mark as exhibit 4.
And Ms. Donnerstag, I think you also had some video clips of while teaching Joe Clyde. Is that correct?
Yes, sir.
And if we could go to the next slide. Well, let me back up. Before we go to the video, can you identify the photograph on the screen?
Those look like the boots that Joe wore.
Okay, now this is not in your classroom,
No, sir.
but those do look like the boots that Joe wore.
They do.
Does this photograph represent what we are seeing on the screen?
Yes, sir.
I will move that as exhibit 5.
This is exhibit 5.
All right, I think we now have a video. Pause that for a second. I need to make sure the volume is loud enough for the jury to hear, because there is speaking. I'm going to start the video up. I'm going to step out of the way.
And what's next? Oh, look. Just loud word. Good. Good talking. And heart. Let's see. Do we have them all? Can you count them? Let me hear you count. Good. Two. E. Good, three. Oh, man. There you go. Okay, this is 1, 2, 3, 4. Okay, what's next? 5. What's next? 8. 6, 7, 8, 9. And that's all? Good job.
So, Ms. Donnerstag, are we seeing kind of layered teaching method here? We're counting, identifying words, saying words, placing objects. Does that have a name for that?
Yeah, so for here, we're just working on just basic communication skills. What I'm seeing on here is that he was varying those words. They were kind of, some of them you could tell what they were, and some of them were kind of word approximation. He was putting two words together with a ball. On that, you can tell that he is participating in a back and forth communication with me. So even though he's not verbalizing like we would expect, he's anticipating what I'm going to say. He's watching me. He's responding to my reactions. He's really doing well with that. And then he's also counting and matching the shape with the silhouette.
Thank you. In your best representation, how did he say the word 5?
It was primarily vowels, not a true F or V sound on those.
Did you ever hear him count past 10?
I don't believe so.
Okay. I think we have another video clip as well.
Okay, come here. Letters. And go. Joe. Joe. Okay, I want to hear you. A. Uh-oh. I don't hear. Say it. A. Your turn. E. Good job. E. Good. E. What's next? A. F. Ah. Good. G. H. I. What is it? J. K. L. M. What is it? C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T, U, V, W, X, Y. What is it? Z. Good job, Joe.
And what's this exercise?
This was letter identification and naming. We were working on a lot of just kindergarten skills as well as communication.
And although I not necessarily could hear the exact letter he was saying, he was pointing. Is that correct?
He was pointing. He was pointing kind of in a, with the pointer, and he was also tapping the letters appropriately, and he was doing it kind of in the pattern that you would expect. So even though he wasn't maybe verbalizing it as clear, he was demonstrating the understanding and doing the skill kind of in a receptive or nonverbal way.
Okay. As a side note, is this about the length of hair that Joe Clyde kept during the school year?
I believe so. He typically had shorter hair.
How would you describe that haircut? I've heard it referred to as a burr.
A burr or a buzz.
Okay. And I think we have one more video.
Hey, Joe. What is it that you're wanting? Apple. Hey, Joe, look at me, buddy. Look, I don't have an apple. I'm so sorry. Do you want me to bring you an apple on Thursday? Are you so mad at me because I don't have apples? Hey, be nice. I'm sorry. I really am sorry. Don't be so mad. We're going to play a fun game instead, okay? No, you want an apple more than anything? Be nice, okay?
And Ms. Donnerstack, did those 3 video clips accurately represent videos that you made of Joe during the course of the school year?
I made all 3 of those.
Okay. Thank you. I'm going to move a copy of the 3 videos as the next exhibit.
Exhibit 6.
Do you know Alex Nolan?
I do.
How did you know Alex?
Like I said, when at Centennial, I pushed in to the preschool class. So during speech and language therapy time, I would go in and I would kind of work with the whole group and do some literacy and language and speech skills. Alex was enrolled as a peer in the preschool class. And so in the 4-year-old class, they came 4 days a week or 3 days a week. So he was actually enrolled in that peer program.
What does that mean to be enrolled as a peer?
In the special education classroom that we had, the way that we had that particular one set up is we had students that had educational disabilities that needed some supports and had IEPs and goals. And then we also had typically developing peers so that they could be an appropriate model so that we could, children learn best from each other. And so the peers kind of help us teach those skills to our students that had the IEPs.
And how would you describe Alex as a model peer?
Alex was an exceptional peer. He was he was just a kind, sweet child. He is one that if a student was struggling, you could always, hey, why don't you go over there and play with him? And he would go over and, here, buddy, let me show you how to do this. So he was very kind, and he was very patient, and just really, as far as a peer comes, you couldn't have picked a better peer for our students.
From your observations, did Joe Clyde like to be around and near Alex?
He did. Alex, I would take Alex occasionally and, have him interact and, just kind of see how they communicate. And Alex loved being around Joe loved being around Alex.
Okay, thank you. Just a couple more things and I'll be finished with the questioning. You described how Joe Clyde was progressing as you would work with him through the week. On a day-to-day basis, you would observe him progressing. What would happen after going home for a weekend or not seeing you consecutive days in a row?
When he would come back to school on Monday or after a break, it took a lot more encouragement to get him to verbalize. And so, by the end of the week, towards the end of it, it came a little easier. And it was, he kind of spontaneously gave me more. And so, but then when we come back, it kind of took me a little bit more. It was, the skills seemed to regress over those breaks in the weekend. And then we would kind of build up throughout the week.
Do skills regress when not being practiced?
Yes.
And you also made a couple of other notes in one of the exhibits we've already marked in your handwritten notes that you had observed over medication of Joe Clyde.
Yes.
And what did you observe?
You want me to say or just
Sure.
read? Okay. Well, I can read if that's okay, and that way I don't speak. Let me find it.
And again, these are from your handwritten notes, which we've made as an exhibit. Is that correct?
Yes.
Okay.
Okay, so I had marked becoming more easily understood within context, spontaneous speech increased. And then I wrote, Joe has been extremely tired during therapy, asked if he was sick, and he responded no. Asked if he stayed up all night, and he responded no. Then imitated drinking something and said, in. And I asked medicine, and Joe nodded his head yes. At bus duty, Joe fell asleep, and I asked Alex why he was so sleepy. Alex stated that it was his medicine. I asked, is he sick? And Alex said no. And I asked, then why did he take medicine? The bus was then called, and Alex jumped up and said, gotta go, and hurried off. And then I just wrote strange reaction. Checked on Joe next day, extremely lethargic, reported to school nurse, went into the lunchroom. He was falling asleep while eating, went back to the nurse, went and got Joe and took him for the nurse to observe, appeared way over medicated. Nurse contacted parents. Next day, appeared more alert and back to his normal self.
Thank you. Thank you for being here today. I'll pass the witness.
Cross-examination.
Joe Clyde, he was not completely nonverbal, was he?
There's different definitions of nonverbal, so I would have to ask your definition of nonverbal.
Well, I mean, he could talk to some degree.
Correct. He had verbalizations that he made.
And if he was prompted, that made it easier for him to verbalize. Is that correct?
He made verbalizations prompted and unprompted.
And unprompted.
Yes,
and
sir.
One of those was as he was counting, he counted to 5, correct?
Yes.
And he counted 1, 2, 3, and then he said 5. And he didn't say it. You said he left off the F, essentially.
I believe so. I think I wrote in my notes, but it was on, oo, e, or, I, something like that.
That's what he said. Like IVE as opposed to with the F, correct?
I believe so.
And so when he verbalized that on the screen, you could tell that he was saying 5.
I could tell within context. I knew that he was counting, so I was anticipating that number. Yes.
All right. And he, as far as his gross motor skills and his fine motor skills, those kind of things, he had a hard time doing sort of small tasks, hand-eye coordination things, correct?
Correct.
But he could move around fairly well. He was not stable, as you said, but you could see him on the video. He was getting around the room, moving around the room fairly easily, correct?
He could walk, yes.
Yeah. And he could use his arms and his hands. He was holding the pencil and using it to point out the things. And
He could use it. Look, it seemed delayed from my standpoint because he was kind of leaning up on the wall and kind of hitting it with an uncoordinated task, but he could do it.
But he was
No, it
grasping.
wasn't typical, but he could do it.
Understand. It wasn't what you would expect from a 5-year-old.
Correct.
But he was grasping that pencil. It was a sort of a long pointer shaped like a pencil.
Yes, sir.
Is that right?
Yes, sir.
And he was grasping that with his right hand, and he was pointing with it. And as he, in the other video, moved around the room, he moved over by the door, didn't he?
He did.
And when he got over by the door handle came to somewhere in his chest area. Is that right?
I believe so.
Okay. So the door handle was where he could easily reach it with his hands, wasn't it?
It was,
Okay. So he could grasp that door handle if he wanted to, couldn't he?
if he wanted to.
And he could turn that door handle and open the door, couldn't he?
Yes.
So he could have walked out of that room had he wanted to do that. Have you seen, well, I mean, you nodded, you didn't.
Yes, sorry. Yes, he could
Yeah,
open the door.
And so he could walk out of the room if he wanted to.
Yes.
He could use doors.
Yes.
Okay. And you've seen him go in and out of rooms using the door handle, haven't you?
Yes.
Okay.
Redirect.
Ms. Donnerstad, you said you've seen him use doors and go in and out of doors. Did he ever escape from your class?
No.
Thank you.
Anything further, Mr. Tyler?
No, Your Honor.
Thank you, ma'am. You may step down. Are we finished with her as a witness? Do we need to release her?
Release.
All right, thank you, ma'am. You are released. You may leave or you may stay as you choose. Call your next witness. Let me first ask, ladies and gentlemen, we're going to go for a while. Does anyone need a recess before we take up the next witness? All right, call your next witness.
Tony Longton there.
I'm sorry,
Tony Longton.
Raise your right hand and face the clerk to be placed under oath.
do you solemnly swear affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please speak directly into the microphone.
Yes, sir.
Good afternoon, Mr. Longton. Would you state and spell your first and last name for us, please?
My legal name is Anthony Longton, Anthony Longtin.
All right, and you go by Tony. Is that
Tony,
correct?
yes, sir.
All right. Mr. Longton, what do you do for a living?
I teach high school at Dixon County High School, and I also drive school bus.
All right. And how long have you been driving the school bus?
Oh, Lord. So again, bus 44's route, I would assume probably 4 years, 5 years maybe on that
Okay.
route.
And does that route take you by the Daniels residence, 1112 Garnish Creek Road?
Every morning.
All right. And that's here in Dixon County, obviously.
Yes, sir.
Okay. Who from that residence rides your bus?
Alex and Joe.
Okay.
Daniel.
They usually ride morning, afternoon, both? Usually ride both.
Yes, sir.
How often would they ride?
Pretty much every morning,
Okay.
every evening, pretty much.
All right. And does your bus, is it equipped with a camera?
Yes, sir.
And does it record kind of behind you what the students are doing as they're moving or whatever?
It is equipped with 3 cameras, all rear facing.
Okay. Let me show you a clip here. Does that, I know it's just a still image there. Is that your bus? Can you tell?
Yes, sir, it is.
All right. And is that Joe Clyde that we see laying down there in that seat?
Yes, sir, it is. That's his assigned seat, his and Alex.
Okay. And Mr. Longton, this is from April the 3rd of 2018. Is that correct?
Should be, yes, sir.
And who do we see there in the foreground? Kind of?
That is Joe.
All right. Who did someone meet them at the end of the driveway that day? Do you recall?
Should have been Aunt Joyce, I believe.
I believe you could hear something about Alex at the end of the drive.
It was usually Aunt Joyce every day.
Okay.
She usually bring them there in the morning and pick them up in the evening.
All right. You're going to ask to make a copy of that video the next exhibit.
We'll mark it as exhibit 7, I think it is.
Yes, sir.
All right, so what we've just watched, that was video of Alex and Joe Clyde getting off the bus on 4-3, correct?
Yes, sir.
Did you pick them up on 4-4 to go to school?
No, sir.
All right. Anybody at the end of their driveway when you went by?
No, sir.
All right. Did you ever notice anything odd that day? Have any interactions with Joseph Daniel or any of them on the morning of 4-4?
That morning, I pulled up to the bus stop. I noticed that nobody was there. I looked behind the house to see if there were anybody coming out there. I looked toward the front, didn't see anything moving or normal, so I just kind of moved on. But when I went to look up forward, I did see his vehicle up at the next stop up the road.
And when you say his vehicle, are you referring to Joseph Daniels, the defendant in this
Yes,
case?
sir, a maroon I can't remember what model, but I believe it was a maroon car.
Okay. And you saw it up at your next stop.
Yes, sir.
And about how far was that from 1112?
From 1112.
From 1112's Garner's Creek, the Daniels residence.
Oh, the Daniels
I'm sorry.
residence. Let's see, 1, 2, 3, 4 houses up, I believe it is.
And his car was up at that house.
Yes, sir.
What was he doing? What was going on?
When the kids got on, said he was asking if anybody's seen Joe, that he was gone, I guess left the house or something.
All right.
The best I can recall, that's what the kids had said.
Okay. And then you went on about your bus route. Is that accurate?
Yes, sir.
That morning? Okay. And then did you, or were you part of, or was it did you get part of the shuttles that were shuttling volunteers around?
Yes, sir.
All right. And was that actually your idea to
Yeah,
get the
I
tell us how
mentioned that
happened.
night. Yes, sir.
All right. Tell us about that. What happened?
We got there the first day whenever we heard everything was gone. So when I got up, I come back around on the old Garner's Creek. That's toward the end of the route. And I seen one of the deputies, and I stopped and said, hey, what's going on with that? And they said, well, it seems like little Joe's missing. So we got there that night. Later on, just see if anybody could help. And I believe I said to Jeff Bledsoe at night, I said, all these deputies moving around, they were looking for trailers and everything else. And I said, we ought to see about getting these school buses out here. We could use mine and we could shuttle people around with it. And I guess that was a good idea. And there they went from there.
All right. And so did the school lend buses essentially to move searchers around?
100%. They were all in for it.
And how many days did y'all run buses shuttling people back and forth different places?
I can't give an exact days. I know I ran 1, 2, I think 3 different times. I believe it's 3 different searches. I believe I ran.
Once in April and then searches after that?
Yes,
All
I
right.
believe that's correct.
I believe there was a search in May as well.
I believe so.
accurate?
That was on the upper side, yes.
All right. That's all I got.
Okay.
No questions.
Thank you, sir. Mr. Longton, you may step down. We're releasing Mr. Longton from the subpoena.
Yes.
You are released from your subpoena. You may stay or leave. Call your next witness.
Chelsea Lampley, Your Honor. Yes, Your Honor.
Someone swear or affirm that the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God.
You will speak directly into that microphone.
Would you state and spell your first and last name for the court reporter, please?
Chelsea Lampley, CHELSEALAMPLEY.
Where do you work, Miss Lampley?
In Dixon 911.
And what do you do there?
I'm a dispatcher.
Did you receive a call about a missing child on April the 4th of 2018?
I did.
And who called, if you recall?
The defendant.
Okay. And was that Joseph Daniels?
Yes.
All right. And obviously those calls are recorded, aren't they?
Yes, sir.
All right. I ask you to listen to this call.
Call 1 on Wednesday, April 4th, 2018 at 6:22 a.m. with a GMT offset of -300 minutes. Agent ID is extension is 106.
Where is your emergency? This is Dixon County 911. Yes, sir. I'm holding on to 112 Garner Creek Road. And my son has been escaped on cannot find him.
Okay, how old is your son, sir?
He is 5.
Okay, you said he was 11,
He
12?
has autism. Yes,
Okay, and you said he has autism?
yes.
Okay, how long ago was he last seen?
Last night,
Okay, all right. And what's his name?
his name is Joe
What's his last name?
Daniels.
What was he wearing last night?
He was wearing pajamas.
What kind of pajamas? What do they look like?
They were orange with the better than I would have had.
Okay. And do you know how he got out of the house?
He must have unlocked the door.
Okay.
And he got out.
What's his date of birth?
7/30/12.
Okay, sir. And you said his name was Joe. What was his last name?
Daniels.
Daniels.
Yes.
Okay. And what's your last name, sir?
Daniels.
Okay, what's your first name?
Joseph.
All right, Joseph. And what does he look like?
He's got blonde hair. And blue eyes.
Okay.
And
Okay, blonde hair, blue eyes. Anything else? How tall is he?
I was like 4, 4 feet tall.
4 feet tall. How much does he weigh?
65 pounds.
65 pounds. Okay.
Yes.
Okay, do you know anywhere where he would go from your house?
I do not know, because we don't know anything except for one neighbor.
Mm-hmm.
So I do not know where he would go.
Okay, is he nonverbal or is he verbal?
It's nonverbal.
Nonverbal?
Yes.
Okay, and how severe is his autism?
It also had a stable consensus about the help that he didn't matter, so, but it's not so severe, but it's pretty significant. Where he takes off and he's unable to communicate.
Okay.
And we have to, he tries to pay himself, but we have to pay him.
Okay, all right, sir, and what's your phone number?
It's 29 867 6984.
Okay, and did he take anything with him out of his room?
I didn't see anything to the room.
No stuffed animals, no blanket or anything like that?
No.
Okay, all right, Joe, we're gonna get him in route to you, okay? Just hang out right there at 11 and 12, we're gonna get him out there to you, okay?
Okay.
All right, thank you.
All right, so Ms. Lampley, working at dispatch, have you received 911 calls about children that were missing before?
Yes, sir.
All right. Have you received multiple calls of that nature?
Yes, sir.
Had some of those children had autism?
Yes.
All right, did you find anything odd about this phone call?
He seemed extremely calm.
And when you say he, who are you referring to?
The caller,
And
Joseph
so-
Daniels.
So, is that something you noticed when you were speaking with him?
I did.
All right. And just a couple things, because his voice on there was a little hard to hear. Did he say my son escaped and we cannot find him?
As far as I know, he said, I think he got out.
Okay. What about, he said about 3.5 to 4 feet tall and nonverbal, correct?
Mhm.
All right. Your Honor, has to introduce a copy of that.
Mark it as Exhibit 8.
And Mr. Etheridge, could we play that call again, just to get the how he got out part?
Call 1 on Wednesday, April 4th, 2018, at 6:22 a.m. with a GMT offset of negative 300 minutes. Agent ID is extension is 106.
Where's your emergency?
That's the county 911?
Yes, sir.
Okay, I was on 112, Glass Creek Road,
Mm-hmm.
and my son had this escape, and we can't find him.
Okay, how old is your son, sir?
Did you hear that time him saying my son's escaped and we cannot find him? All right. Is that typically what you hear when someone's calling in a missing child report?
It was much clearer than I'd have.
Sure. But I mean, is that the wording you typically hear when someone's calling and saying their child's missing? And at dispatch, do you create what's called a CAD card when you get a call?
For every call.
All right. What is a CAD card? What goes in there?
It is basically a log of the data for each call.
All right. And did you do that in this call?
I did.
And what kind of data does it log?
It logs the caller's phone number, location, the type of event that is going on, their Latin long of where they are at the time of the call, and a short narrative of what's going on.
And does it also log officers on scene and kind of what time they get there, that kind of
thing? It does. Every unit that's en route or assigned.
Passing the document here. Is that the CAD card for this case?
It is.
All right. Your Honor, asked to make that the next exhibit, please.
All right, next exhibit will be 9.
And was that call made at 6:22 a.m.?
Yes, ma'am.
All right. That's all.
Any questions?
If parents and grandparents of autistic kids sometimes refer to those kids escaping their house, you're not saying that means they're a criminal or anything like that, are you?
No, sir.
And are you familiar that that often autistic kids will get out of the house or get out of the school?
Almost any child will.
All right. And this call, my client called you to get police to come to his house.
Yes, sir.
That's all I have.
Redirect. Thank you, ma'am. Are we releasing her from her subpoena? You are releasing your subpoena. You may go back to.
Thank you.
All right, you may call your next witness. All right, ladies and gentlemen, this will probably be a jury out hearing, and you can go ahead. We'll take a recess after this to give you a chance to stretch your legs and have a restroom break. You'll step across the hall, please.
Your Honor, may counsel be excused briefly for restroom break?
Are you going to do that? Let one of the other counsel argue this, whatever it is we're about to take up, or do you want to take your recess before we take up the matter? You need to go to the restroom. Let's just go ahead. Let's go ahead and take our recess. Let's take a, well, this will be our afternoon recess. We'll take a 15-minute recess.
All right. For some recess.
Recording stopped.
Okay, who's staying with jury tonight?
I think I can.
I think I can.
I think I can.
I think I can.
I think I can. I think I can.
I think I can.
I think I can. I think I can.
Welcome to the afternoon session on law and crime. I'm Saima Chowdhury. Now, we've been following the trial of California versus Robert Durst, but we're switching gears a bit, getting our audience caught up on another trial starting in just a few days from now, the trial of Tennessee versus Joseph Ray Daniels. Joseph Daniels is on trial for the murder of this boy, his son, 5-year-old nonverbal autistic Joseph Clyde Daniels. He's also known as Baby Joe. Now, Baby Joe was last seen on April 3rd of 2018, and his father called 911 to report his son missing the next day. To this day, Baby Joe's body has never been found. Now, the prosecution alleges that the 5-year-old was beaten to death after urinating on the floor. Again, Baby Joe's remains have never been found. Additional charges for the defendant include child abuse, aggravated child abuse, child neglect, filing a false police report, and tampering with evidence. Today is day 2 of jury selection. The jurors for this case are being selected in another county, and they'll be sequestered for the trial. Our Brian Buckmeyer has a preview of how this will all go down.
He must have locked the door.
Okay.
He got out.
Joseph Ray Daniels called 911 on April 4th, 2018, to report his son as missing. Daniels said his 5-year-old with autism, Joe Clyde Daniels, known as Baby Joe, was last seen the night before.
I did not know where he was gone.
Okay, is he nonverbal or is he verbal?
It's nonverbal.
Nonverbal.
A search was launched for Baby Joe in Dickinson County. State investigators were called in. But 3 days later, those investigators said Daniels confessed to murdering his son.
His exact words was he was bleeding, but he said he did not see blood.
Daniel reportedly said during a 5-hour interrogation that he hit Baby Joey until the boy stopped crying. Daniels described putting the boy in the trunk of his car and leaving his body in a field. Daniels took investigators to that location, but the 5-year-old's body has never been found. Daniel has since recanted. His defense says he suffers from mental health issues and calls his confession coerced.
And you don't have any physical evidence outside the alleged confession that the child was killed or carried anywhere.
Physical evidence. I did not collect any. I am aware of physical evidence related to a shovel, but I'm not aware if that's been any information relating to that shovel has been confirmed or not.
Investigators say there was no physical evidence of the child living in the house and said it could have been cleaned before it was searched. Daniels is charged with criminal homicide. The boy's mother, Krystal Daniels, is charged with aggravated child neglect or endangerment. She's also accused of helping to cover up the crime. A judge previously ruled the two would be tried separately. Daniels is the first to stand trial. Jury selection is scheduled for Tuesday and Wednesday. Jurors will be selected from another county and will be sequestered during what is expected to be a 1-week trial. Opening statements are set for Thursday. Daniels is being held in jail on a $1 million bond.
All right, ladies and gentlemen, thank you. You may have a seat. I believe at this point, the state's ready to call their next witness. Jeff Bledsoe. Step right up and raise your right hand and be placed under oath.
Do you solemnly swear upon the testimony you give in this case to be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Good afternoon. Would you state your name for the court?
Jeffrey Dean Bledsoe,
And would you spell your last name, please, sir?
Bledsoe.
All right. And what do you do for a living?
I am the executive director for the Tennessee Sheriff's Association.
Okay. And back in 2018, how were you employed?
I was sheriff, the elected sheriff of Dixon County.
All right. So I'm still going to refer to you as Sheriff Bledsoe, if that's all right, because that's what I've called you since I've known you.
Yes, sir.
So Sheriff Bledsoe, how did you become, did you become involved in the search for Joe Clyde on April the 4th of 2018?
Yes, sir, I did.
All right. And who'd you get a call from, I suppose?
I believe it was my chief deputy, Jerron Holt, gave me a call that morning of the call that we had responded to.
Okay, and then did you go out to the scene after that?
Yes, sir, I did.
Okay, describe the scene as it was when you got there.
When I arrived, we had personnel on scene, and there were searches that were already initiated with K-9 and communication with the family, and things were just starting to evolve and get, I guess, spin up at that point.
Okay, and what did you do when you got there?
My position was to oversee what we were doing and the personnel that we had on scene, and to start formulating what plans we would need to have an exhaustive search at that time.
Okay. And at that point, was the Dixon County Sheriff's Department, the TBI, kind of working side by side on this? Or was it mostly the Sheriff's Department at the time you arrived?
At that moment, it was just our office, and then later we started bringing in extra resources and making those connections for an alert and things that we would normally do.
All right. And that's something I want to get into is kind of other agencies and the overall scope of the search, if that's all right. About what time did you arrive on scene?
There were so many days that I arrived on scene. I'm not positive, but I would say somewhere between 8 and 9 a.m. It would have been after things that were initiated by the patrol division that did the initial response.
Okay. And then through the day, did other agencies begin to kind of filter in as requested to help with the search?
Yes, sir.
All right. Now, I've got a PowerPoint prepared. And before we get into it, you and I have gone over this PowerPoint pre-trial. Is that right?
Yes, sir.
And there's a bunch of agencies listed on here, and you've gone over those, and those were people that were on scene to help with the search. Is that accurate?
Yes, sir. To the best of my knowledge.
Sure.
I'm not
There was
sure
a lot
it's
of people
inclusive.
out there. Is that fair?
Yes, sir.
I believe at last count, there were something like 24 agencies from different parts of the state and the United States that showed up. Is that an accurate representation?
Yes, sir.
All right. So the main two agencies involved in this case was TBI and the Dixon County Sheriff's Department.
Yes, that's correct.
All right. And go to the next slide, please. Obviously, we had several other state agencies that showed up to help. What did the Red Cross do as part of the search?
They're tremendous with the support that they provide for just basic needs on scene, for taking care of the personnel on scene with food or looking for a way to shelter in place. And I believe they provided even a mobile restroom facility initially.
All right. And what about the Tennessee Highway Patrol? What was their function on scene?
It was a numerous, voluminous task that they would have. Initially, I think we had support from their aviation unit with their helicopter, and troopers were arriving on scene to either assist throughout the process with the searches or control of the traffic that was in the area, or on the major highway. We had issues with traffic getting backed up down to that area, or people across the highway. So they were huge support with their mobile command coming and just their team effort with the search.
Because I imagine with all the volunteers we had, there was a lot of cars around, things of that nature.
Yes, sir. We didn't have enough place for them, but we found areas to get.
All right. And go to the next slide, if you will. And this is just the other sheriff's departments that showed up to help. Is that accurate?
Yes, sir, it is.
Cheatham County, Humphreys County, and then Bexar County, Texas. What did they do?
They specialize in use of drones and equipment that they can use as they fly over areas that can help us to pinpoint certain vegetation that is rich in nitrogen and allows us to go back and look at those areas as a point of interest.
And so all that was utilized as part of this search and the ongoing searches?
Yes, sir, later after that initial.
Sure. All right, next slide, please. And then this is just the local police departments. Of course, the Dixon Police Department, Kingston Springs, and Fairview Police Department. They all provide manpower to come and help search?
Yes, sir, they did.
All right. And then the next slide, please, sir. Of course, we had multiple agencies, smaller agencies, state, local, that showed up. Tell us about some of the emergency management agencies. What were they providing?
They're crucial in establishing our own scene command and documenting with something this large of scale and the duration. We would need to document the actions and radio traffic and what information they receive could be channeled to the scene. And then that's kind of our point of communications. And they also do much more than that with logistics of taking care of our people with food and drink and any of our needs that we need. And that is just a big support to an operation when we're on scene.
Sure. A lot of people out there to help try to support and organize.
Yes, sir. And they have a mobile vehicle that has computer-aided dispatch terminals within that vehicle to help us to log everything and to track as much as we can.
Sure. All right. And the next slide, please. All right. And Sheriff, so is this kind of an overview of the area of Garners Creek Road? Can you see that?
Yes, sir, I can. It starts, looks like from about 3rd Street going south.
Would this be 3rd Street up here?
Yes, sir, right there.
Going across that way?
Yes, sir.
Then we've got Garners Creek Road coming down this way. Is that right?
Yes, sir.
Does that appear to be the residence?
Yes, sir, it is.
All right, and then is this old Garners Creek Road coming down that way?
Yes, sir, to the west side of the Garners Creek.
Next slide, please, Mr. Evans. And then, as you stated, there were a couple helicopters, I think, that were flying. Did we go over some footage from one of those helicopters that kind of shows the command center and the search that was ongoing?
Yes, sir, we did.
All right, Mr. Etheridge, if you will play that, please. And Sheriff, that right there, is that kind of the command center where everybody was set up, kind of gathering information was coming to, that kind of thing?
Yes, sir. The homeowner allowed us to use his driveway and pretty well turned over his shop to us for us to have shelter and places for people to rest. But that's kind of the nexus or the center of the incident command.
Sheriff, is that you and that group of people there huddled up, kind of talking?
Yes, sir. I just put my coat over my arm with the uniform on.
So Sheriff, from this view here, the 1112 Garners Creek, the defendant's home and Joe Clyde's home is kind of up above where the screen is. Is that accurate?
Yes, sir. Would be at the top beyond the screen.
Okay. The school buses, what were they being used for, Sheriff?
We had such a large scale presence for search. We used those for transportation to deploy teams to certain areas on the map to do a thorough search.
Whose helicopter is that there? If you know, sure.
It's one of our agencies that partnered with us. That's Tennessee Highway Patrol.
And they were actually flying a search pattern of some sort. Is that accurate?
Yes, sir. They were assisting from the aerial aviation side.
Now, I believe Sergeant Baker, who was one of the first to arrive on scene, went up in the helicopter first. Is that accurate?
That's my understanding. Yes, sir.
Your Honor, it has to move that video in as the next exhibit.
46.
Yes, sir.
Sheriff, I'm going to show you a photo. Does that appear to be the photo that we showed on the screen earlier, just an overview of the area of Garner's Creek there?
Yes, sir, it is.
And same photo that's up on the screen now.
Yes, sir, it is.
All right, that's to make that the next exhibit, Your Honor.
47.
I'm going to hand you a series of photographs. Could you identify those photographs?
Yes, sir. They appear to be satellite imaging of the area of the scene that we were at, and has different overlays on the map.
And was your department involved in the creation or helping to create what's known as a SAR map?
Yes, sir. We were involved with that.
All right. And what kind of information went into that map?
Each team that we deployed, we would place a tracker on them, and that tracker would communicate with the software. I don't know all the complex details of the technology, but it would map where that tracker would go, and we could take sections of the map and make sure we covered everything within the radius and scope of our search.
Okay. And I'm going to put an image up here on the screen. Is that the first image that you have there in your hand?
Yes, sir, it is.
And could you describe kind of what that image is?
It looks like towards the top, that will be Highway 70, and off to the right of middle would be where Garner's Creek comes down. It's kind of in yellow on the screen where the road's highlighted, but off of 70.
Highway 70 up here.
Yes, sir.
And Garner's Creek is coming down right through here.
Yes, sir, that's correct.
And what are these shaded areas? What do they all represent?
Honestly, sir, I'm not sure what the colors represent on that. It may have been areas that we still needed, but I can't say for sure.
Is that how kind of the area was broken up to be searched in different areas?
Yes, sir. We could take what was naturally there in the terrain, or property lines, fence lines, tree lines, and that would help us to stay on target of what areas we needed to be in, because it's totally different on the ground than what you see from the aerial.
Like this when you're from the ground.
Yes, sir. Correct.
Your Honor, has to make that the next exhibit. Next.
48.
Yes, sir.
Now, this is kind of a crazy picture. Is this a more blown up view of the area that we were looking at?
Yes, sir. It's zoomed in, more detail.
And the SAR map, would it include details of what was searched and that kind of thing?
Yes, sir. It should have the tracking from those GPS trackers to show each movement. It just lays a line on the map.
Okay. You're gonna have to make that the next exhibit. Sheriff, what are we looking at here?
It's of the same area with Highway 70 near the top, and it's the Tennessee City area. And it, again, it's got the grids on it. I couldn't tell you what exactly each color and point is specifically to this map.
Okay. Is this Highway 70 up here?
Yes, sir.
So would this area with all the colors and words be the area of Garner Street and the residents?
Yes, sir. Those were primary areas that we needed to initially focus on.
And what is this yellow line down here?
That's Interstate 40, which is in the southern end of our county.
What about all of these red lines? What do those represent?
I'm not positive what exactly those lines are at this point.
Okay. And so area from up here was all searched around the residence?
Yes, sir.
And then did the search extend down south towards the interstate here?
Yes, sir, it did.
You're gonna estimate that for next.
Yes, sir.
Sheriff, is this a zoomed in view of the south portion of what we were just looking at?
Yes, sir, it is.
And this shaded area here and these red lines, that indicate search areas that were searches conducted?
Yes, sir, this should be from the GPS tracking.
Next exhibit, please. And then this photo, Sheriff, what is this yellow box here? Is that an area that was searched for more thoroughly along with these red lines from the GPS?
I know it was an area that was searched thoroughly. I do not recall the date or anything like that, but yes, sir, it was an area of interest for us, and I think that's why it's highlighted.
And this road here that we see down south, what is that?
That's, again, Interstate 40.
In relation to the residents, where is Interstate 40?
Interstate 40 is south of the residence.
About how far? Do you have any knowledge of that?
I would say 6 to 8 miles. I'm not positive on the mileage.
It's multiple miles.
Yes, sir.
Fair statement. That's to make that the next exhibit.
Yes, sir.
Sheriff, this over here, does that represent the Harris Road area? Or what represent, is that where the Harris Road area is with all these search marks around it?
I'm trying to get my bearing on this map here.
It can be difficult.
So I believe that line going across maybe is the TVA right away where it's got the cleared path across, but this is so small I can't quite distinguish which area that is, but that would be consistent with that area.
The Harris Road area, was that an area of interest?
Yes, sir, it was.
And was that area searched, kind of combed through multiple times?
Yes, sir, thoroughly.
All right. And when an area is searched, you said the team carries that tracker with it. Is that what the red lines are? The team that marks on the map where the team goes?
Yes, sir. And the way it's so many paths there, it colors it in where it's hard to recognize what's under it. So yes, sir.
I understand. And Judge has to make that the next exhibit, please. Next slide, please, Mr. Etheridge. So we've spoken about there were many volunteers that showed up to the search. Is that a fair statement?
Yes, it is.
When did they begin showing up?
Day one, we started with some initial searches, and then that continued on for quite some time.
Did volunteers, how were they organized, or did they have to register first?
Yes, sir. We wanted to vet those that were searching, and we had some parameters of how many people we could have per team so that we could manage everything and not let everything just be all over the place. So everything was strictly under guidelines and protocols that would be consistent with search teams and incident command, how many people would be with a leader of a team.
All right. right. So we were able to essentially track how many people we had out there on the ground. Is that fair?
Yes, sir. We wanted to make sure everyone was documented and the areas were documented.
All right. And how you said the search team, teams went out or the people went out in teams. How are those teams formed and who led them, if anyone?
From the first day, I asked for our special response team to come in, and those were coordinated with people outside of my administrative level, that those teams, when they got on, were put into certain areas and certain groups with them. I would have to look at the documentation because we were doing so many different things at that point that I was depending on others to structure the team and make sure I would oversee and look in and see where they were going and could see the map in pretty much real time, or once it laid it back over on the map. But I couldn't tell you exactly how that was organized.
Did every team have an officer with them?
Yes, that's my understanding. Yes, sir.
Okay. So a team of volunteers would go out and there would be an officer placed with them and a GPS tracker to record where they went.
Yes, sir, because we needed that local communication too with our dispatch on scene and incident command to have the local radio traffic and that's consistent. Yes, sir.
So the first search, we just kind of got it grouped there, was from April the 4th to April the 6th. Is that accurate?
Yes,
The
sir.
initial search, I guess we could call it.
Yes, sir.
Were more searches conducted after that with citizen volunteers?
Yes, sir.
All right, and is that the dates that we have listed up there?
Yes, sir. May 19th was our largest search where we could expand that out and have the proper resources, and there was an operations plan put together and members were vetted who would be team leaders that had certain backgrounds within search and terrain. And so it was all organized on the 19th. That was the largest one that we had.
And the May 19th search, I mean, that was well after charges were filed in this case. Is that correct?
Yes, sir.
So did the investigation, did it ever really stop? The search, did it ever stop?
No, sir. If today there's anything of interest, there would still be searching. There's no doubt in my mind with that. And if anyone says that we stopped searching, that would be misleading.
Sure. All right, next slide, please. And then this is a list of, well, let me ask it this way. Were there multiple searches conducted by the Sheriff's Department and other police agencies that didn't include citizen volunteers?
Yes, sir. Specifically for the law enforcement realm.
And I'm going to hand you a document. I know that's probably hard to see from where you're seeing it. What does that document list out that I've handed to you?
The left column lists the dates, and the right column gives locations and the agency in brackets that participated in these numerous searches.
And what's the date range from the top to the bottom?
From April the 8th until May the 19th of this year, 2021.
So May the 19th of 2021, it's just a couple weeks ago.
Yes, sir.
Okay.
Yes, sir.
The honor has to make that the next exhibit, please.
54? Yes, sir.
All right, next slide, please. So we talked a little bit about resources that were used. TBI and THP air. Were there ponds that were searched?
Yes, this area is just vastly populated with bodies of water and ponds. It's more than any other area, I think, in our county. But it was a logistics undertaking just to cover the waters that were in that area.
And how was that done?
We had help from a number of sources with dive teams, or that could put boats in. They could use conventional technology to drag the scene. There were some that were able to help that had the underwater cameras, or TWRA has a device that's similar to a underwater drone or a robot that has camera systems, and they can put that in, and the operator can run certain grids, patterns, depending upon the size of the body of water, and it just depends on the depth and the volume, the size.
And then, of course, we had multiple police agencies on the scene, including the special SWAT team and the cameras. Were there, to your knowledge, did you see dogs being used, search and rescue kind of dogs being used?
Yes, constantly.
All right. Next slide, please. Were you involved, and to your knowledge, were there some experts that were brought in to try to help with this?
Absolutely, yes, sir.
Dr. Berryman and Dr. Jantz, are those the doctors that would kind of review any bones that were found to your knowledge?
Yes, sir.
All right. And Dr. Arpad Voss, what did he do? What is he helping them with the search, or what was his role?
He has a specialty in which it's a scientific measure that I wouldn't be knowledgeable of to try to explain, but I did vet him. I was given references of agencies that he had assisted across the country, and I called and spoke with probably 3 or 4 different agencies in which he was able to assist, and I was able to verify that his technology has proven itself. And through the help of TBI, we were able to fly him in and have him assist with the search.
I believe he worked on the Casey Anthony case in Florida, did he not?
Yes, sir. That's my understanding.
All right. And then Dr. Michael Gibson, I believe he brought in a ground penetrating radar. Do you have any knowledge of that being done?
Yes, sir. I remember the name and the use of the technology.
All right. Next slide, please. All right. Sheriff Bledsoe, have you ever been involved in a missing child search that was this large in Dixon County?
Not at this scale, no, sir.
Have you ever known of one in Middle Tennessee, to your knowledge?
There's another one that comes to mind in another county, which there was a child missing, but I don't know the scale of their operation compared to ours. I'm sure it was everything, every resource they could find.
All right. And Your Honor has to make that PowerPoint.
This.
Yes, sir. Just a moment, please, Your Honor. That's our question, Judge.
Close examine.
Hi, Sheriff. Been a while.
Yes, sir, Mr. Locker.
The searches that took place were even thorough in regard to, I believe, a psychic had called in and thought maybe the child was in a well. That was followed up on too. Is that correct? Do you recall that?
We had numerous tips from people that represented as psychics, and everything that I was aware of was followed up on.
All right. And very extensive and meticulous search and investigation. Would that be fair to say?
Yes, sir.
And was any physical evidence found indicating that Joe Clyde Daniels was murdered?
Not that I was involved with, no, sir.
All right. And was there any physical evidence found that indicated that Joe Clyde Daniels was even dead?
No, sir, not that I'm aware of.
And did your department or other agencies go to the house where a lady called in and said her child's shoes or boots were taken off her front porch that same early morning or night this Joe Clyde went missing?
Yes, sir. From the best of my knowledge, I remember something with the lady calling about boots and maybe the barn, and that was checked.
Did they take dogs out there to try to pick up a scent?
I don't know on that. No, sir. I'm not sure.
Do you feel like that's something that should have been done?
If we had the dogs on scene when we checked, yes, sir.
All right. And did you have a meticulous GPS search done of the area where the lady called in and said her daughter saw a little boy in dirty pajamas?
I don't recall that, sir. That may have been after I left the sheriff's office. I'm not positive. Do you know a date on that?
It would have been within 5 days or less.
Oh, 5 days from our initial response?
Yeah, from.
For some reason, I remember pajamas, but I don't remember anything that would have been reported to us. I know through our process of documentation and review of all that information that was coming in, that it was followed up on. If that one wasn't, then it's escaped my radar.
If that was not followed up on, that would be a pretty serious mistake, wouldn't it?
It would need to be reviewed, yes, sir. We need to talk to that person.
And would you also want to do a GPS search in that location?
I would want to get all the facts of what was described and seen, and then make a determination if we needed to use resources to search that area.
But I mean, if a mother told you her child said she saw a little boy in dirty pajamas within a few days of Joe Clyde missing, that would want to be followed up on, wouldn't you?
Yes, sir. If it fits the description and everything, even beyond that, we may want to talk to some neighbors or something just to see what that would be about, see if we could validate it.
But if they say it's a little boy in dirty pajamas, even if they can't give a great description.
Hearsay at this point. He's getting into what someone else said, often after the truth of the matter asserted.
Ladies and gentlemen, step out, please. All right, your objection is as to hearsay, but this is really a question that's asking, and Mr. Locker has done this on another occasion, asking a witness about an incident that we've had a pretrial hearing on, in which I ruled we would not allow the testimony of the mother to come in and testify that the daughter made the statement. I'm assuming that Mr. Lockhart may have her as a witness and may bring the child in and let her testify because he's asking these questions. I don't know that, but it don't seem to, but it does seem to me that right now what he's asking this witness is about a hearsay statement of the child that I've already ruled would not be admissible because of the factors that I cited in my ruling. I'm not sure how it would be applicable to this. He's being asked a theoretical question about an event or a piece of evidence that I've ruled, at least at this point, is not admissible under the form of the mother testifying of the child's statement. If the child were to come in and testify, that'd be a different matter. She's the one who actually had the firsthand knowledge. So that's my concern, is that the question that's formulated right now is the mother's reported that the child said she saw a child in dirty pajamas, and that's the very thing that I have ruled on as being inadmissible in that form. So my concern is allowing the question to this witness that seems to suppose that information is coming in, because I think in a way it may or may not be coming in depending on whether the child is going to testify. But your objection is as to the basis of hearsay, is that correct?
It's hearsay and I didn't want to get into the out-of-court hearing in front of the jury, but relying on the court's prior ruling that this is hearsay and can't come in absent the girl testifying. And what's happening now is Mr. Lockhart's trying to get in double hearsay, the child's statement to the mother and then the mother's statement to Mr. Lockhart. So certainly, I think certainly the court ruled that he can ask if there was a lead that was followed up on, which has been done and answered. But getting into what the child supposedly said, we would object to as hearsay.
Judge, we also ask for an instruction to the jury to disregard Mr. Locke's entire line of questioning because he is in clear violation of the court's pretrial ruling. That's why we had his lengthy motion on this issue with multiple witnesses. We have a transcript from that hearing. He is in direct violation of this court's order. And the jury needs to be instructed to disregard that entire line of questioning.
Mr. Lockhart, you wish to respond?
Yes, Your Honor. Your Honor had ruled that statement could not come in as to what the girl saw for the truth of the matter asserted. This is not being asked for the truth of the matter asserted. The state has gone to great lengths with multiple pictures and GPS maps, and 20-something agencies come in to show how meticulous and thorough their search and their investigation was. I'm simply trying to establish that there were these two reports that came in, not the truth of the matter asserted, but based on the report, the same late night or early morning hours this child went missing, a woman's child's shoes were taken off the porch. Dogs weren't brought in to try to follow that or trace it. No evidence of a GPS search to try to find who put those shoes on and left with them. And then the incident where the lady said her child saw a little boy in dirty pajamas. The court already knows from a previous hearing that there was no meticulous GPS search. The testimony was that officers drove up and down the road and stopped at bridges and looking over. So this comes in to show, again, bias of the investigation, and also to contradict the sheriff's testimony that this was this broad, expansive GPS search with multiple agencies. It goes to show that it was not that thorough. It was not that meticulous, and that they had leads. They even followed up on psychic leads where psychics would call in. Yet you have a mother that calls in that her child's shoes were taken off the porch this same time period. That's not followed up on. So it's not for the truth of the matter asserted, and I think the court should charge a jury. That's not introduced for the purpose of the truth of the matter asserted, but it's introduced to show evidence of bias in the investigation. And that's clearly under the law. And Your Honor ruled I could ask about the reports and the effect it had on the officers and what they did, is my recollection.
I believe the same argument you're making now is the same exact argument you made at our motion hearing, and that was that it ought to be coming in to show bias of the investigation. And I made the ruling that I made because it was essentially double hearsay. The child was only 4 years of age, and the mother, when she testified, said, I asked if the child was available to testify. She said she doesn't remember any of this happening. And so the unreliability in that particular situation was what caused me to lead me to exclude the evidence. I think the point of fact is that you've asked the question and stated in your question the fact that, if there was a report that was made such as that, the evidence of that report being made will not be introduced under my ruling. You've asked the question about whether they followed up on such a lead, and my ruling, I'm going to sustain the objection as to any further questioning about that and instruct the jury that questions are not evidence. And the fact that you've asked a question was purpose of trying to show what the defense's position is about the extent of the investigation and whether other leads were given that weren't followed up on. But that's the sole purpose for which that question was asked.
And also, Your Honor, since the jury's out, will the same type ruling being in place, because we've already heard hearsay from a 3-year-old, is the court going to require that 3-year-old come in to testify?
You were in the courtroom when I made my ruling, correct?
Yes, Your Honor.
And you heard the basis of my ruling was that it was an excited utterance, and it did not require that under that case, the State versus Franklin case, the 2010 Supreme Court decision, did not require that the person be absent or be brought into court in order to admit an excited utterance. And that was the basis of my ruling. I do not find that there was no argument at the hearing that we had that this statement by this 4-year-old child regarding her supposedly having seen a dirty boy in pajamas or boy in dirty pajamas, there was no argument made by the defense propagating that was an excited utterance. It was simply a statement made by the child allegedly to the mother, and the child doesn't remember the statement being made. So I am applying the same standard because of the fact that two things don't apply. Your client, or rather your position is that I ought to require this child at 3 years of age to come in, and excited utterance exception, which I rule upon, does not require that. So my position is that I have ruled correctly on that, and that's what I'm going to do when the jury returns.
So at this point, I just want to make sure I'm clear. I'm not to ask any more questions about this. And I think that's what the court's saying.
What I'm saying is that you've asked this officer if they got that report, did they do an aerial search? And he's answered he's not even aware of that report being made. You've asked him, wouldn't that be important if that report came in to make that search? And he, I believe, said it would be important. And I think, how much further do you feel that you need to go to establish your issue about the search?
I'm just wanting the clarification. I don't need, what I asked was about a GPS search. And I don't intend to ask about an aerial search. I just want to clarify where we're at. So I'm not to ask any more questions about these reports because it's been covered.
The report of there's been no objection to the report about the boots being missing, and that's been brought out in other testimony. There was no hearing about the boots being missing from a neighboring house. There's no hearing on that where I've had to make a ruling. The only ruling I've had to make is on the report about the child seeing the little boy and allegedly seeing the boy in dirty pajamas. And that's what I've ruled upon, and that's what I'm saying. It would be inappropriate to continue asking questions about that particular issue regarding when I've made that ruling. So
yes, Your Honor.
I've allowed it. I'm not going to tell the jury to disregard it, but I'm going to give them a limiting instruction that would allow them to consider it only for the purpose of demonstrating anything else, and remind them that the question that you ask is not evidence.
Yes, Your Honor.
All right.
All right.
Mr. Crouch.
My only follow-up to that is, first of all, the question from Mr. Lockhart, not only in violation of your order, but he didn't give the sheriff any indication of where this report came from. Your Honor is aware from the hearing, this was a report made in Humphreys County, which Sheriff Bledsoe would not be aware of. And we had two witnesses that testified from Humphreys County Sheriff's Department eliminating this possibility. First of all, well, I'm not going to go rehash that entire argument, but I think the jury needs to hear that the report Mr. Lockhart is referring to is from Humphreys County. So Mr. Lockhart never even directed the sheriff as to what county the report came into. He immediately went into the violation of your order. And I'm asking that be reflected to the jury.
I'll be glad to ask him if he knows the location, how far away it was. I don't know that he knows that.
Well, I'm going to bring the jury back in, and I'm going to instruct them, as I've said, that the questions of lawyers are not evidence. And I've given them in my initial instructions, and they will hear again, and that the question that Mr. Lockhart asked about certain other reports being made have not been introduced as evidence, and therefore they're not to consider them as evidence that those things actually occurred. They were asked by Mr. Lockhart of this witness to try to show whether or not there had been as broad an investigation as he contended in his testimony, or as the state seemed to present, but that they are not to consider what Mr. Lockhart asked in his question as being substantive evidence that those things actually occurred. And I'm going to leave it at that. Mr. Lockhart, I don't intend to apply any sort of sanction in telling the jury to disregard your entire line of questioning. I understand your theory behind but I do think that it's the same argument that was made at the hearing. So let's be sure if you're going to intend to try to do that again, let's try to make sure the jury's out and you propose that question before we go any further.
Yes, Your Honor.
Bring the jury back. Thank you. You may be seated. Ladies and gentlemen, as I told you before, my job is sometimes as the rule keeper or the gatekeeper or the enforcer of the rules. In your absence, I considered an objection the state had to the line of questioning that Mr. Lockhart was asking about other reports. I would remind you of what I've told you in our initial instructions, and that is questions that whether it's the state or the defense, a lawyer's questions to a witness of reports being made and how that affected or what steps were taken in it. There's been no evidence presented to you of either of those instances taking place. So those questions are not reflective of substantive evidence that has come before you. They are just questions that are designed to say that if such a report had been made, should it have been followed up? And the officer has testified what his knowledge was about either one of those reports. But I'm instructing you to disregard any inference that might have come from the asking of that question that such reports were actually made in this situation. They were made, the question was asked by Mr. Lockhart to help you, and I told him this is how I'm going to address it, to help you understand his position was that the search was not as widespread as what the state's position it was. Does everyone understand that? All right, so if you'll follow my instructions in considering that evidence, then we'll go forward. Mr. Locke, do you have any other questions?
No further questions.
Mr. Turnbow, do you have any follow-up?
Just briefly, Judge. So Sheriff Bledsoe, Mr. Lockhart made mention of the fact that there was no physical evidence found. What day was the missing child reported? Recall the date?
The initial response?
Yes, sir.
Yes, sir. That was April the 4th, 2018.
All right. And from April the 4th until later on, over 2 days later in the afternoon of April the 6th, was there a criminal investigation going at that point, or was it just for a missing child?
Later that day, it turned criminal.
Later that day on the 6th?
Yes, sir.
Okay. So there were 2 days there, over 48 hours, where it was just law enforcement, citizen volunteers, 24 agencies looking for a missing child.
Yes, sir.
Was the defendant in custody at that point?
No, sir.
Was he free to roam about where he wanted to go?
Yes, sir.
He was not under surveillance, wasn't being followed, was he?
No, sir. Not that I know of.
Okay. So essentially, there was a 2-day head start.
Yes, sir.
That's all, Your Honor.
No further questions. Thank you, Mr. Bledsoe. You may be excused. I call your next witness. Raise your right hand and face your close.
Thank you. Do you solemnly swear from the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
When you have a seat, if you'll step in, speak into that microphone as loudly as you can.
Yes, sir.
Could you state your name for the court, please, sir?
Patrick Looney,
And how do you spell your last name, Mr.?
Looney.
And what do you do for a living?
I'm a assistant special agent in charge over the TBI's aviation unit.
All right. So as part of your duties in the aviation unit, what do you do?
A wide variety of search and rescue operations, covert surveillance work, everything in support of multiple agencies.
All right. So do you actually fly an airplane for TBI?
Yes, sir.
Okay. So you're a pilot?
Yes.
And what kind of, you said you fly search and rescue missions. Is that using TBI's plane?
Yes.
All right. Tell us a little bit about how you would get involved in a search. Where would the request come from? What would happen?
They come from a wide variety of areas. Sometimes it'll be a DA's request. Sometimes it'll be inside with our field agents in cooperation with the local agencies. If they have a need for an air asset, that they would filter that through us either by phone or email or just however means they need to get in touch with us.
All right, and we have a PowerPoint we'll get into here in a minute, but what are some of the plane's capabilities to help in a search and rescue type mission?
The TBI has Pilatus PC-12. It's an intelligence, surveillance, and reconnaissance aircraft, as well as a passenger and agent and law enforcement transport aircraft.
Okay. And let's get into the PowerPoint here if we can. And Special Agent Looney, you and I have gone through this PowerPoint before.
Yes, sir.
And does it accurately reflect the plane's camera and pictures and video that were taken that day when you started flying?
Yes, sir, it does.
All right. And just kind of a couple more introductory questions, I guess. Did you get a call to go on April the 4th of 2018 to Garner's Creek and help in the search of a missing child?
Yes, sir, I did.
And did you respond to that request in the airplane?
Yes, sir, we did.
You recall about what time you got up in the air over Garner's Creek?
Probably just sometime in the beginning of the morning.
All right. And this photo here, what does this appear to be, Special Agent Looney?
This is a still image from what the camera system inside our aircraft will produce. Looks like it's in infrared or thermal imaging.
And this red dot, that's a dot or a circle the blue place. Is that where the residence was at 1112 Garner Street?
Yes, sir.
Okay. Next slide, please. All right. What are we seeing here on this still image here? We have the video we'll play, but is that thermal imaging from the plane?
Yes, sir, it is.
Tell us a little bit about what does thermal imaging mean? What does it actually do?
Well, it's what the camera does in that specific camera that we have in the payload bay. It measures temperature differential.
Okay.
So it only sees in black and white, and the camera, there's an algorithm. It gets kind of down in the weeds, but it takes temperature differential from a specific area that the camera is looking at. Algorithm puts a picture together, and there's two modes you can do. You can either do white hot or black hot, and just depends on which one has the most clarity for the image we need.
All right, let's play this video. Special Agent Looney, what is this right here?
Looks like wildlife, probably a deer.
And why are those showing up white?
The particular mode that we have is white hot. So if you'll notice that the head of the animal is hotter than the body, and a lot of times it's just like a human would kind of show the same way. The darker colors would be a cooler surface.
Okay. All right, let's go on to the next slide.
On the right side of the image, you can tell that looks like cows in a feedlot.
Talking about right around here.
Yes, sir.
Okay. And they're also showing up white due to the mode.
The body heat, correct.
Body heat.
Yes, sir.
And I believe you said earlier that's how a human would show up on the camera.
That is correct.
All right. Let's go to the next slide. All right, so let's talk about there's a lot going on here.
It's busy.
So tell us about, and there's a video clip we'll play which may help, but tell us about what's kind of going on here.
Yes, sir. This is a color daytime image. There's multiple information inputs that's compiled into this image. So if you look in the left side where it looks like a picture from a camera, and then you'll see the blue lines.
This right here?
Yes. That is the color camera image. And the blue lines that you're seeing kind of drawn across that is we have the capability to, before the airplane takes off, we can program in search grids. So if the airplane is above an address making a circle in an orbit, the camera has the technology to where it can methodically search in a left to right pattern or north, south, east, west, whichever way we program it.
So while you're flying circles around the area, the camera's staying on these blue lines and checking the grid.
That is correct.
accurate? Okay.
And it's a lot of information that comes in, and the camera operator, a lot of times what this allows us to do is to take this image back and review it in closer detail while we're on the ground instead of being in flight.
Sure. All right, let's go ahead and play.
The other images you see kind of in the middle of those, that is just a mapping software that we use to represent house numbers, street names, map and parcel data.
So now here we're kind of zoomed out on this side. And does this show kind of a zoomed out view of where the plane grid is, where it's flying?
The search grid, yes, sir. That is correct.
And how this is playing special agent, let me ask you a question. So while you're flying the plane, do you have someone else operating the camera and kind of working through all this stuff?
Yes, sir, that is correct.
So it's kind of a two-man operation when you get called out on the scene.
Yes, sir. Top of the screen shows altitude above ground, latitude, longitude, and then slant range distance from whichever target we're looking at to the belly of the aircraft.
Okay. And so this on the right, this is just a zoomed out view of what the camera's seeing here on the left, zoomed in.
That is correct.
Let's go to the next one. And so what are we seeing here, especially?
Yes, sir. Whenever we have a search like this, if it goes beyond our duty times, this allows us to be able to take our search grids and forward those to crews that come on after we go off duty. That way there's a continuity of search area and everyone knows where we've searched and where we have it and where we need to add to.
So that's what's shown here is the grids that they're searched and
Yes, sir.
researched.
One sortie would be the green area and then a follow-on sortie would be the blue area.
Okay, and this, what is this here?
Looks like spaghetti noodles, but this is a representation of the flight path of the aircraft over a search area. That's a Google Earth image, and the white lines are the exact path that the aircraft took over the ground.
And so that yellow dot there, is that the residence in question?
Yes, sir.
Okay, and then all the white lines is where the aircraft was flying while the camera was doing the search grid.
Yes, sir, that is correct.
All right. Your Honor has to make the PowerPoint next exhibit, please.
56.
Yes, sir.
That's our questions for Special Agent Looney, Your Honor.
The new cheesy bacon fondue burger.
Robin. Yum.
Any questions from the defense?
No questions, Your Honor.
Thank you. I'll show you my step down.
Yes, sir.
Sorry. You may be excused if you like.
Yes, sir.
Next witness.
Yes. State calls Detective McCartney.
Raise your right hand.
Do you solemnly swear or affirm testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Good afternoon.
Good afternoon.
Would you state your full name for the court, please?
Sarah McCartney,
Thank you. And would you spell your first and last name?
SARAHMCCARTNEY,
Thank you. And Detective McCartney, where are you employed?
with the Dixon County Sheriff's Office,
And what's your position there?
a detective.
And how long have you been a detective?
I've been a detective for almost 5 years.
And how many years have total service do you have in law enforcement?
A little over 10 years.
And Detective McCartney, were you working on the morning of April the 4th of 2018?
I was.
And were you dispatched to the Garners Creek area?
Yes, sir.
And why were you dispatched there?
My supervisor had called me that morning a little bit before 9 and told me what was going on and said that I needed to respond to the house.
Okay. And do you know approximately what time you arrived on scene at 1112 Garners Creek?
I arrived on scene at 9:08 a.m. that morning.
Okay. And what did you do when you arrived?
When I arrived, I immediately went inside the house. I knew my supervisor was in there. He had told me that he was going to be speaking with the parents. So I went inside to see what he needed me to help him do, and he was there speaking with Krystal Daniels.
And when you say he, who are you referring to?
Sergeant Trevor Daniel. That's my immediate supervisor.
And you went inside the residence?
Yes, sir.
And who all other than Sergeant Daniel did you see inside the residence?
I saw Krystal, the siblings of Joe, Clyde, Alex, and Noah, and an Aunt Joyce.
Okay. Anybody else at home at that point in time?
No, sir.
All right. Do you know where the defendant was?
I did not know.
But he was not in the residence?
He was not.
What else did you do while you were at the residence or on that property?
While my sergeant spoke with Krystal, I noticed Alex standing there. So I took an opportunity to speak with him for just a moment and kind of get his take on things. And he told me that he didn't really know what had happened, but he did show me where he and Joe Clyde had been sleeping the night before. And he just pointed out to me what sides of the beds they were sleeping on. He pointed out to me that someone had used the toilet and not flushed it. And he thought that it was Joe Clyde, but he didn't give me a reason why he thought that. He also told me that Joe Clyde had had an accident during the night and had urinated in the floor.
Okay. What'd you do after that?
After that, another one of our detectives had arrived on scene, Detective Troy Martin. He began photographing the scene, and I was just kind of with him observing and just to see if we could see anything that needed to be photographed or anything that needed to be pointed out.
Did you walk around the residence with Detective Martin as he was taking photographs?
I did.
All right. And I have a stack of photographs that I would like for you to look through and identify before we go any further.
Yes, sir. These are the pictures that Detective Troy Martin took at the residence.
Okay. And if I could have Mr. Etheridge go to the first photo. And Detective, starting with the first photo in the stack, is what you're seeing what is on the screen?
Yes, sir.
And can you identify that photograph?
This is the mailbox of 1112 Garners Creek Road, the residence of the Daniels.
Thank you. And Detective, can you identify any of the vehicles that we see?
There's a THP unit there in the driveway facing the road. The black truck, I'm not sure whose that is.
Okay. Now, when you say the THP vehicle, is that parked at 1115 Garners Creek?
Yes, it is.
So that's not in the Daniels residence driveway, it's across the street?
Right there. The Daniels mailbox is across the street from their own driveway.
And is that a for sale sign that we see at the location of 1115?
Yes, sir, it is.
And do you know the name of the residents or the owners of 1115 on April 4th, 2018?
That would have been Jeff and Cheryl Smithson.
And Detective, if you will go to the next photograph, I'll move that as next exhibit.
Number
Detective.
57.
47?
50.
57. Detective, the photograph that you have in your hand, does it match what we see on the screen?
It does.
And can you identify what we're looking at?
It's the mailbox. Just see the same THP vehicle there. The maroon vehicle you see parked on.
And the next photo?
This is going to be a picture of the outside of the Daniels residence, the front of the house, and their driveway.
Move that as exhibit 59. This photograph,
This is the mailbox, the other side of the mailbox.
and on this, we see 1112 Daniel, and what's the other name on the address?
Austin.
And are we looking north or south in this photograph?
In this photograph, you're looking north towards Highway 70.
Move that as the next exhibit. Detective McCartney, is the photograph in your hand the same as on the screen?
It is
And what do we see?
the outside of their home.
Detective, as you were going around the outside of their home, did you see any markings in the yard that may have been caused by a vehicle?
It looked like there were tire tracks going from the front yard.
Move that as exhibit 61.
Yes, sir.
Detective, what's this next photograph?
It's another picture of the outside of the home, more towards the side, and you can see one of their storage sheds in the back.
And are you in this photograph?
I am. I'm standing right beside that silver SUV.
The silver SUV that you're standing next to, is that who's that belong to?
Detective Troy Martin.
And the other vehicles that we see are a silver Impala and a tractor trailer.
Yes.
Move that as exhibit 61. 62. So Detective, are you and Detective Martin essentially photographing the exterior of the residence right now?
Yes, the entire perimeter.
And what is this photograph?
This is going to be the north side of the house.
Move that as exhibit 63. What's this photograph?
This is a silver Impala that also belonged to the Daniels family.
Move that as exhibit 64. Detective, can you identify this photograph?
These are their two storage sheds that were located behind the home.
Move that as exhibit 65. All right, Detective, can you identify this photograph?
This is the back of the residence.
And Detective, what does this appear to be in this back deck?
On that table,
Yes.
a Power Wheels car.
Okay. And what about next to the railing on the deck?
It looks like boots.
Boots? What other item is behind the boots?
I can't tell.
Okay. Move that to the next exhibit.
66.
And Detective, what do you see in this photograph?
The truck, the green truck that belongs to the Daniels family, the storage sheds, the backside of those.
Move that to the next exhibit.
67.
It appears you're going around the house counterclockwise, is that correct?
Yes, sir.
And what do we see in this photograph?
This is still the back of the residence, but more towards the south side.
And do we see a better idea of the tracks you were describing earlier?
Yes, you can see tracks. Looks like they're going around the trailer.
And I'm going to point, what do you see here?
Car tracks.
Car tracks going around the house?
Yes, sir.
Right. Do those tracks continue all the way around?
They do, out to the driveway.
And in this photograph, what do we see here?
That is going to be the defendant's vehicle again.
Move that as exhibit 68. Next photograph, continuing around the house, is that correct?
Yes, sir. We're back to the front, towards the south side of the house.
What do we see here?
The tire tracks.
Move that as exhibit 69. Detective, what do we see in this photograph?
This is the front of the house, and again, you can see the tire tracks continuing around the house.
Move that as exhibit 70. Okay, Detective, it appears that you have approached the rear entrance to the house, is that correct?
Yes.
And can you describe what we see in this photograph?
This is the back porch, and that's the back door. They use that as their main door.
Okay. And do you see any items placed in either of these chairs?
No, sir.
Move that as the next exhibit.
71.
And Detective, can you identify this photograph?
That is the steps that are leading up to the porch that we just had a picture of.
Move that as exhibit 72. Detective, it appears that the rear door of the residence is open, is that correct?
Yes.
And what do you see as you enter the rear door?
There are toys in the entryway.
Move that as exhibit 73. Detective, is this, I don't know if you can see from there, what do we see on this?
That is a latch that was at the top of the door. It was used in conjunction with a padlock to keep the door secure.
Move that as exhibit 74. And Detective, is this a close-up of the interior side of the rear door?
Yes, sir.
And what am I pointing to here?
That's the other part of the latch.
Move that as exhibit 75. Detective, can you identify what we see in this part of the photograph?
That is going to be a sticky fly trap and the latch for the door.
And that latch is on the interior side of the door?
Yes, sir.
Move that as exhibit 76. All right, Detective, what do we see in this photograph?
That is from the inside of the door, and the door is now closed. The latch that was used with the padlock.
Move that as exhibit 77. And Detective, can you identify this photograph?
This is the key that went to the padlock that was located on the mantle of the fireplace.
I'll move that as the next exhibit.
78.
Detective, please identify this photograph.
You're looking at that same back door from the inside. That's the entryway, the fireplace to the left, and toys in the floor.
Move as exhibit 79. All right, Detective, describe this photograph.
This is in the living room. We're just to the left side of that door, and there's again toys in the floor.
Move this as exhibit 80. And Detective, please describe this.
This is the padlock that would have been used on that back door. Detective Troy Martin, he's holding it as he photographs it.
Move that as exhibit 81. You identify this, please.
That is the key to the padlock.
Move this as exhibit 82. Okay, Detective, start with the left side of this photograph and tell me what you see.
That is the TV that's in the living room. In the reflection, you can see myself and Detective Troy Martin. You can also see the reflection of Alex and Noah.
And what is Alex wearing?
Looks like he's wearing a white AC/DC t-shirt.
From this photograph, can you see what Noah is wearing? Just a second.
Looks like he's wearing a blue shirt from this picture.
And what is this item on the floor?
It's an Easter basket.
And do you remember when Easter was in 2018?
I think it was just a Sunday prior to this happening.
So roughly 3 or 4 days prior to this?
Yes, sir.
And what do we see here?
That's a China hutch, and it's placed in front of the front door of the trailer to prevent that door from opening.
Move that to the next exhibit.
83.
Okay, Detective, which room of the house are we looking into in this photograph?
This is considered the master bedroom, and it was the bedroom of Belle and Big Joe.
And what's hanging on this door?
Another Easter basket.
And can you identify what this is on part of this door?
It's another type of latch to keep doors closed.
Now, is this a single door, or are we looking at 2 doors?
It's 2 doors.
And can you describe some of the items or what this is on the floor of the bedroom?
There's a step stool, some toys, and maybe a small lockbox.
And these little white dots, do you know what those are?
To my knowledge, that was just trash.
What exhibit are we on?
On 84.
I'll move this as exhibit 84. Okay, Detective, what do we see here?
That's that same set of double doors leading to the master bedroom, just closer up.
And on the left of the 2 double doors, can you identify what this is?
It's half of the latch that would keep those 2 doors locked.
If you close those two doors, would this latch and lock be on the inside of the bedroom or the outside?
The outside of the bedroom.
So if you locked it, it would be locking something in the bedroom?
Yes, sir.
Next photograph, I'll move that to exhibit
85.
and way off. All right, detective, what do we see in this photograph?
We are inside the master bedroom, looking towards the back of the house.
And again, these photos are being taken on April the 4th, 2018.
Yes, sir.
What am I pointing to?
That is a bar stool with a shirt hanging over the back of it.
Is it a stool or a chair?
A bar chair. It looks like a bar height chair.
And here?
Same type of chair.
Do you see a laundry basket anywhere in this grouping of furniture and other items?
I do not.
All right. Move that as the next exhibit.
86.
And what do you see in this photograph?
That's right beside the bed again with the step stool, the lockbox, and the trash in the floor.
Move that as exhibit 87. All right, what do we see?
That's the other side of the same bed. And it looks like there's some more trash in the floor and a toy.
Move this exhibit 88. Are we still in the master bedroom of Miss Bell and Big Joe?
Yes, sir.
And what is this photograph?
That's going to be of one of their bathrooms. There's actually 2 bathrooms in that bedroom.
Move this as the next exhibit.
89.
This photograph?
It's still in the master bedroom.
Move it as exhibit 90. This photograph?
The master bedroom again.
Move that as the next exhibit.
91.
And this photograph is directed.
I believe that's the other bathroom inside the master bedroom.
So there are 2 bathrooms in the master bedroom.
Yes. And I believe they're connected with a closet.
A closet goes in between the 2 bathrooms.
Yes, sir.
Move that as exhibit 92. We're still in the master bedroom.
Yes, and I think that's kind of the closet area in between the bathrooms.
Move that as exhibit 93. Detective, does it appear that the photograph is being taken from one bathroom through the hallway into the other?
Yes.
Move that as exhibit 94. And this photograph?
That's going to be the other bathroom.
Move to exhibit 95. I'm sure we can skip ahead. Detective, is the photograph you're holding the same photograph that we see on the screen?
It is.
And what is this?
It's just another picture of that bathroom.
Move that to the next exhibit.
96.
All right, let me stop right there. Detective, just what's the purpose of taking so many photographs?
We try to take pictures, as many pictures as we can of everything so that if we need to refer back to them later, everything was documented. So we try to take pictures of everything.
So at this point, Tom, I mean, it appears that we're looking at a photograph of some Christmas wrapping paper and a green ball and a red ball and an Amazon box.
Yes.
I mean, at this point, Tom, is there something significant about those items?
No, sir.
And is there ever anything significant about these items?
No.
But you're just trying to document the scene?
Yes.
Move that as the next exhibit.
97.
What is this?
That is going to be in a closet, but I am not sure which one.
Move that as exhibit 98.
That's in that same closet.
Still in the master bedroom?
I believe it is.
Move that as exhibit 99.
And that's the closet again.
And I'll move that as exhibit 100. All right, detective, are we out of the master bedroom?
Yes, sir.
Where are we now?
This is going to be the living room.
And what do you see in this photograph?
That is a coffee table. There's a bottle on it and some clothing.
Do you know who the bottle belongs to?
I do not.
And what is this?
A toy truck.
What's this?
It looks like either a toy or a piece of trash.
And what are these items?
Clothing.
What's this? The white
It's a pair of socks,
and this
a pair of blue jeans,
and this.
a plaid shirt.
Okay. So, see any other clothing items on this table at this point?
I do not.
Move that as the next exhibit.
101.
All right, what do we see here?
It's the same coffee table from a different angle.
And you see a plastic hammer
Yes, sir.
on the floor next to the table?
Yes.
And what do you see on the couch?
Another toy truck.
Move that as the next exhibit.
102.
And what's this?
This is cropped from a picture that you saw earlier, but it's a picture of the side of their house, and out on Garners Creek Road, you can see the maroon Impala parked on the road.
Move that as the next exhibit. And Detective, you've shown two pictures of the maroon Impala parked on the road.
Yes.
And you justified that was the defendant's vehicle.
Yes.
But the defendant wasn't home when you got there.
He wasn't home when I got there. He got back to the house probably within 10 minutes of me getting there because Sergeant Trevor Daniel asked Krystal if she would call him and ask for him to return home so he could talk to him. And so within 10 minutes, he returned to the house.
After you finished taking the documentation photos, what did you do next?
At that point, we had received some information that dogs had tracked to a pond behind the house, and that the pond was going to be pumped and searched. So I went back to that pond and observed.
You observed the pond being drained?
Yes, sir.
All right. And what did you do after that?
After that, South 3rd Street is right behind that pond. It's very close. And several of us had congregated in that area to just talk about what our plan was to do next. And Detective Jeff Lovell, who is one of my coworkers, received a phone call at that time from the defendant, Joseph. And Joseph asked,
The defendant gets back home.
Yes, sir.
And you have just gone down the street to 3rd Street.
Yes.
The defendant calls and asks for someone to check his trunk.
That's right.
After he returns home.
Yes.
All right. What did you do next?
After that, I didn't go check the trunk. My supervisor, Sergeant Daniel, he did that. After he checked the trunk, Sergeant Daniel asked me and Detective Lovell, would you guys ask Joseph if he minds riding with you guys and showing you where all he looked for Joe Clyde? So we asked him and he agreed to ride with us and show us where he looked.
And I want to be super clear on this. When you say you asked the defendant to ride with you, was he under arrest?
He was not.
Had he been approached or confronted about any type of criminal activity?
No, sir.
Had he been free to come and go all morning long?
Yes.
Was he free to say, I'm not riding with you?
Yes.
Was there any pressure of any nature used to get him to ride with you?
No, sir.
All right. And did you record this ride as you drove the defendant around?
Yes.
And we have a recording of that today. Is that correct?
Yes.
And at this point, I'm going to move a copy of the interview or of the recording of yourself and the defendant and Detective Lovell as you are driving around Garners Creek.
That will be Exhibit 104.
Thank you. And before we start, we have transcripts for the jury to follow along with. We could distribute those. Judge, we'll need a couple of minutes for the defense to look at our transcript.
Well, let's go ahead and just take a recess and stretch our leg before we start into this video. How long is this video?
It's over an hour.
Over an hour, so we'll need to go ahead and take our afternoon recess right now. Thank you. We'll be in recess in 15 minutes.
All right.
Recording
This court is in
stopped.
recess.
anything else, just sitting there reading my own chat.
Are you guys still here? Yeah, guys, I think that's all there was for available on Long Crime streams for day 2. Day 1. So I don't know what you guys would like to do in the meantime if you're still there. Okie dokie, I'll get the other one started. All right, I think I found the local feed out of Nashville. This may be a little more inclusive. Nope. So let's see here. All right, guys, I've got one set up. Tell me if this is the right.
I've got a power. State's ready to call. You may have. All right, ladies and gentlemen, thank you. You may have a seat. I believe at this point, the state's ready to call the next witness.
All right. Got to back this up about a minute and it will start. So here we go. Share screen, the tab of Chrome. So here we go, guys. I apologize. Message me at the top of the chat. Yeah, let me try to work on that. I got to figure out how to do the StreamYard thing. Move. Okay. All right, guys, here we go. I'm going to probably just have me zoom out and let the trial go. All right. Let's start. Bon appetit.
All right, ladies and gentlemen, thank you. You may have a seat. I believe at this point, the state's ready to call their next witness. Jeff Bledsoe. Step right up and raise your right hand and be placed under oath.
Do you solemnly swear upon the testimony you give in this case to be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Good afternoon. Would you state your name to the court?
Jeffrey Dean Bledsoe.
And would you spell your last name, please, sir?
Bledsoe.
And what do you do for a living?
I am the executive director for the Tennessee Sheriff's Association.
Okay. And back in 2018, how were you employed?
I was sheriff, the elected sheriff of Dixon County.
All right. So I'm still going to refer to you as Sheriff Bledsoe, if that's all right, because that's what I've called you since I've known you.
Yes, sir.
So Sheriff Bledsoe, how did you become, did you become involved in the search for Joe Clyde on April the 4th of 2018?
Yes, sir, I did.
All right. And who'd you get a call from, I suppose?
I believe it was my chief deputy, Jerron Holt, gave me a call that morning of the call that we had responded to.
Okay. And then did you go out to the scene after that?
Yes, sir, I did.
Okay. Describe the scene as it was when you got there.
When I arrived, we had personnel on scene and there were searches that were already initiated. with K-9 and communication with the family, and things were just starting to evolve and get, I guess, spin up at that point.
Okay. And what did you do when you got there?
My position was to oversee what we were doing and the personnel that we had on scene, and to start formulating what plans we would need to have an exhaustive search at that time.
Okay. And at that point, was the Dixon County Sheriff's Department, the TBI, kind of working side by side on this, or was it mostly the Sheriff's Department at the time you arrived?
At that moment, it was just our office, and then later we started bringing in extra resources and making those connections for an alert and things that we would normally do.
All right. And that's something I want to get into, is kind of other agencies and the overall scope of the search, if that's all right. About what time did you arrive on scene?
There were so many days that I arrived on scene. I'm not positive, but I would say somewhere between 8 and 9 a.m. It would have been after things that were initiated by the patrol division that did the initial response.
Okay. And then through the day, did other agencies begin to kind of filter in as requested to help with the search?
Yes, sir.
All right. Now, I've got a PowerPoint prepared. And before we get into it, you and I have gone over this PowerPoint pre-trial. Is that right?
You can't have an office when you're not in an office. Well, unless you have Connect Team. With Connect Team's app, you can easily track your employees' hours in real time. Get the
decision of our Tennessee Supreme Court. All right, we're back on the record. Just wanted to remind everyone.
Okay. So how far did you guys get? Did you guys get through the full couple hours? That's I think that's the one you guys are looking for, right? I'm sorry, didn't mean to cough on mic. I assume that's the one you guys are looking for, correct? Just let me know. Because I'm going to start from here. If this is one you have not. Okay, you think that was the last video? Okay, I'll get this one started up then.
But
Recording in progress.
I'm going from the jury returns to go ahead and advise them that the first question that was asked has Mr. Mitchell had asked it and the witness had responded. Second question is one that there will be further evidence on. So.
And Your Honor, I don't have any objection if you want to tell them what the answer was or have the court reporter read it. He answered it. So. Never mind.
I'll look back at it.
We can question some more.
Well, I don't care if you question him or not. I'm just saying my point was that Mr. Mitchell asked the question and it was answered, and that normally is sufficient. That was handed to me before he had finished his questioning. So bring the jury in.
Full screen. Autoplay is not on because Long Crime
Jurors have
doesn't
asked
have the
if they
full
could have a
setup.
tour at some point of the
There are-
Justice Center building. Anybody have any objection to letting them have a guarded tour?
Guys, there's an issue about not everybody's. Long Crime doesn't have this one set up like the other trials. It's kind of broke up. So this one's kind of a mess to catch through. So I think that's why I went from one source to another source. So I'll just leave this here for today.
Ladies and gentlemen, you may be seated. Before we took our break, I was handed two questions. The first question was, did Mr. Morris perceive Noah's words as a question or a statement? Mr. Mitchell had asked that question.
Oh, this just lets the jury ask questions?
Before we took
That's
our break.
super
So I
cool.
think it was after this question had been handed to me. And then the second was, was the tractor trailer ever searched? And I'm just going to ask him, but then advise you, Mr. Morris, do you know of your own personal knowledge whether the tractor trailer was ever searched while you were there?
No, sir.
All right. But I am advised by both sides that there will be evidence on that particular question. So there will be some additional evidence on the search of the tractor trailer. All right. And your last question is whether or not you can get a tour of this building. You absolutely can get a tour of this building, and we'll try to conduct that under appropriate circumstances when the time is available to us. So we have a brand new justice center that county mayor and county legislative body has gifted us with, so to speak. And if you had to be trying this case in the old courthouse where we were, it would be a completely different scenario. This is a beautiful building, and it's really helping us to get this case over with in a much better environment. All right, with that then, are there any other questions for Mr. Morris? Defense have any other questions?
No, Your Honor.
Thank you, Mr. Morris. Then you are free to go.
Thank you.
All right. State may call your next witness.
Chad Bailey.
Chad Bailey. Step right up again and raise your right hand one more time. Let the clerk place you under oath.
Do you solemnly swear or affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am. So help me God.
Thank you.
Mr. Bailey, will you state your full name, please?
William C. Bailey.
Thank you. Will you spell your first and last name?
William, William, last name Bailey, Bailey.
Thank you. And Mr. Bailey, where do you work?
I worked with the Murray County Office of Emergency Management. I'm a special operations chief.
Okay. And how long have you been doing that?
I've been employed with them doing this for going on 5 years now.
5 years. And what was your background before your current position?
I'm also full-time employed with the City of Columbia Fire Department. I've been with them going on 13 years. I've been in emergency services almost a total of 31 years.
31 years?
Yes, sir.
So
started very early.
Yes, you must have. So in 31 years of emergency operations experience, is that fair to say?
Yes, sir.
All right. And what is a search and rescue team?
Our STAR team and what they do, we are deployed for missing persons, people who have Alzheimer's and wandered off, children who've wandered off or from home. We assist law enforcement agencies in locating those people, along with we've assisted State Forestry Service, State Park Service and stuff.
And who makes up the SAR team or search and rescue team?
We have a very broad group. Our team consists of law enforcement agencies, partners, firemen, EMS personnel. We have some park service. A lot of vast majority of them are volunteer.
Okay. Do you use any type of specialized equipment?
We do. We use thermal imagings. We do. Been through a lot of them. Been certified through man tracking school. We actually, our office, our former director, helped create kind of the program that the state Tennessee Office of Emergency Management utilizes now to teach agencies on how to do search and stuff. Okay. We utilize a lot of technology, computer-based programs, unmanned aerial devices, and stuff like that.
What about canines?
We do utilize canines. We have 2 handlers that we primarily use that are part of our teams. They have been on countless searches and made countless finds.
Thank you. On the morning of April the 4th of 2018, were you dispatched to go to Dixon County, Tennessee?
Yes, sir. Director Blackwood received a phone call around, just off the top of my head, I believe around 11:30ish, from TEMA Regional Operation, TEMA Air Representative Michael Reinhardt, requesting the possibility of a mission for a missing autistic 5-year-old.
Okay, so you got a call for a mission to assist with a missing young boy.
Yes, sir.
Is that fairly common to go outside of Maury County?
Yes, sir.
Do you have an agreement or interlocal agreement with other counties or Middle Tennessee to do that?
No, sir. We'll just go off of their requests.
If somebody calls,
we'll go anywhere.
Good deal.
If requested.
Do you know about what time you arrived in Dixon County on April the 4th, 2018?
From the time we received the initial phone call request to the mission was actually accepted and processed, we got our group together. I believe we arrived around maybe 1 o'clock in the afternoon-ish.
1 o'clock on April 4th, 2018?
Yes, sir.
Did you go to a command center first?
Our first assignment, which in the vehicle that I was driving with a retired director, Blackwood was with me. We were leading. We initially were sent to the Tennessee City Fire Station.
Okay.
Once we met up there, I believe he made contact with either Brent Morris or Michael Reinhardt. They redeployed us to the scene at that intersection. Unfortunately, I'm sorry about that. I don't know the names of the streets. I just know the main road. But we met there.
After you met up with, I think you said Mr. Morris from TEMA, where did you go then?
We got our assignments. I parked my vehicle in a driveway. Our team with their trailer, our support trailer was located and positioned off a side street. We rendezvoused and got our assignment, said a quick prayer, and on foot walked to the home.
Did you go to 1112 Garners Creek Road?
If that's the address, I believe, yes, sir.
Okay.
The address.
Thank you. Now, Mr. Bailey, I'm going to show you a series of photos. I'm going to show them to you one at a time.
Yes, sir.
First, can you identify this photograph?
Yes, sir. This is a photograph of the back porch, the
back porch of the residence.
The back porch of the residence we went to, the doorway that we utilized to enter and exit the structure.
Thank you. And Mr. Bailey, I'm going to ask you to look towards the big screen. And does what we see on the screen, is it the same photograph that I've got in front of you here?
Yes, sir.
All right. I'll move that as the next exhibit.
Oh, sorry. Thank you.
All right, Mr. Bailey, can you identify this photograph?
Yes, sir, I can.
What is that?
This is the interior, the upper left corner of the doorway with a clasp and a fly trap.
Thank you.
And now, sorry. I'm sorry, I didn't understand. What?
A clasp, like a locking clasp.
You said something else too. What else did you describe in that photograph?
A fly trap, a hanging fly trap.
Is a fly trap hanging from the ceiling?
Yes, sir.
I'm going to ask you to look at the big screen. Are we looking at the same photographs?
Yes, sir, we are.
I'll move that as the next exhibit.
34.
And Mr. Bailey, can you identify this photograph?
Yes, I can.
What is that?
That is a key that appears to be to a master lock that was located on the mantle against the wall.
The mantle inside the residence that you went to?
To the left, yes.
And now look at the big screen, please. Oh,
Yes, that is it.
same photograph?
Yes, sir.
Mr. Bailey, can you identify this photograph?
Yes, I can.
What is that?
That is a master padlock
Okay. And where is that master padlock located?
laying on a mantle on the fireplace, above the fireplace.
Thank you. Now I'll ask you to look at the television. Is that the same photograph?
Yes, it is.
All right, thank you. Yeah, I need to make those last two photographs, the next two exhibits. I think they'll be 36 and 37.
35 and 36.
One off. Mr. Bailey, can you identify this photograph?
Yes, sir. This is looking from the interior of the home, looking out that doorway. The corner of several toys collected in the corner and some toys standing by the fireplace with the TV on the right.
Thank you. And I'll ask you to look at the big screen.
This is the same photograph.
All right. I'll move that as Exhibit 37. Now, before we go on, Mr. Bailey, you see all the toys. Is that how the toys appeared when you arrived?
Yes, sir.
And you, about what time did you enter the residence, if you can recall?
Approximately maybe 25, 30 minutes after we had arrived initially on scene. So I would say putting that around maybe 1:30-ish.
And can you identify this photograph?
Yes, I can.
And what is that?
That is of the coffee table.
As it appeared when you arrived?
Yes.
All right. And is it the same photograph that we see on the big screen?
Yes, sir.
I'll move that as the next exhibit, please. I'm going to leave that photograph up on the screen for just a minute. Mr. Bailey, when you first arrived at the residence, did you go all the way inside, or where were you?
No, sir. Director Blackwood and Brent Morris with TEMA, they were going in to conduct a lost person questionnaire. That is a form that we perform on every operation we go on. That's one of the first things we do before we really do anything to get our basic information on who we were looking for. At that time, I stood at the doorway that was shown in the photographs.
The doorway with the latch at the top?
Yes, sir. Yes, sir.
And that's where you were standing in the doorway?
Yes, sir. I had my foot in the doorway and stood in the corner. It's hard to describe it.
Sure.
I had my foot holding the door open where I was listening and observing and taking mental notes at that point.
Okay.
I did not want to go in at that point.
And you testified that the purpose for Mr. Morris and Blackwood going inside was to complete the lost person's questionnaire?
Yes, sir. They in certain situations in the past, the more people in there kind of causes some issues. So the less people in, it kind of makes it a more better environment for the people to open up and discuss things.
Okay. As you were standing at the door, did you hear a child say anything?
I did.
What did you hear?
I heard a young child voice speak kind of loudly, come in and say, "Joe dead, Joe dead, Joe dead."
And how many times did you hear that?
Approximately 3 to 4 times.
Okay. Did you hear a response?
I did hear a response. It was of an older female voice. "Yes, baby, Joe dead." All right.
And you're sure that a child said, "Joe dead, Joe dead, Joe dead"?
At the time, again, I have children of my own, and it was not an adult, mature voice. It was a younger voice.
Okay. Now, could you see the person or child that made the 3 remarks, "Joe dead, Joe dead, Joe dead"?
At that point where I was positioned, no, sir.
You could only hear.
I only heard.
And could you see the person that responded, "Yes, Joe's dead"?
From where I was standing, not at that point, no, sir.
Okay. What did you do after you heard those statements?
Mentally, I thought to myself, this just escalated. Did I just hear what I just heard? I looked at a deputy who was standing on the other side of the door who was there with us, asked him, "Did you just hear that?" His response was, "No, I didn't hear anything. I couldn't hear nothing."
And what was his position in relation?
He was more standing off to the left or side, farther away from the door, not as close as I was.
In the exterior of the home?
Exterior of the home. At that point, after collecting my thoughts, I migrated into the doorway with the door closed behind me.
When you went inside the residence, did you have a conversation with the defendant?
Yes, at that point, Mr. Daniels was standing over near the fireplace or had come up to me at the fireplace.
What did the defendant tell you?
Every question I'll ask people in that type of situation is what is your relation He explained it. He was the father. Some conversation was carried on. I don't remember the particulars to it, but I asked the question about the lasp on the door, and he explained to me, yeah, we lock it because he likes to run off. I said, okay. I said, well, was it locked? His response was, I found the lock in the toy box.
The defendant told you that he found the lock in the toy box.
Yes, sir.
And was there a toy box or anything?
The toy box to the right, there was two.
Okay.
There was like a toy box in the corner and then like a wagon, a reddish toy box that had the other toys piled on it.
Did the defendant tell you how the lock got back on top of the mantle?
I asked him something to the fact that, well, how do you think that happened? Or how he said, well, he said he believed that he pushed that table over, climbed up on top of the table, found the key and unlocked it. And then at some point must have pushed that table back to where it was and exited the residence, all while they were asleep.
That's what the defendant told you.
That is what was told to me.
That the missing child had pushed the coffee table to that door?
Yes, sir.
The door that you were standing in?
Yes, sir.
And he told you that he found the lock?
Yes,
and the
sir.
key and unlocked the padlock?
Yes, sir.
That's what the defendant told you?
Yes, sir.
And the defendant also told you that he recovered the padlock?
Yes, sir.
From the toy box?
Yes, sir.
And you saw a photograph of the key on the mantle, is that correct?
Yes, sir.
All right. What did you do then?
I mentally noted that.
What did you think?
No.
What did you think? Is that what you asked?
Yes, sir.
It would seem to me to be asking for him for his impression or opinion about something, would it not?
Yes.
How is that admissible?
Well, he's just described what the defendant told him as to how Joe Clyde Daniels escaped, and he's standing in the room observing whether it was possible to move the table over to the door and climb up and unlock the padlock and push the table back over to the center of the room and leave without anyone noticing it.
I think under the way you have the question formed, you're asking for his mental impression or whatever. I think that under the present form of the question, I would have to sustain the objection.
Yes, sir.
You can rephrase your question.
Yes, sir. What did you do next after the defendant made those statements to you?
Not much. I just explained we'll do our best to try to locate him. They were still finishing up the loss questionnaire at that point. Once that was complete, then we had permission from them to have two of our team members clear the structure from top to bottom. That's a standard practice we do. We do another search of our own. So we were at that point 100% accurate that the child was not in that trailer or that home.
As part of the search and rescue team, did you go to other residences, you and or members of your team, with K9 and search?
Yes, sir, we did.
All right. I'm going to ask you if you can identify this map.
Yes, I can.
I want you to hold that for just a second, but I'm also going to put it on the screen so that everyone can see it. Now, Mr. Bailey, we have placed some yellow thumbtacks at different addresses. Are those addresses that you and or members of your team went to with a K9 unit?
Yes.
Okay. And I'm going to step over to the big screen.
I'd like to add, yes, with a K9 unit and by foot.
K9 unit and foot.
And foot.
And I'll start with the location in which the lost person questionnaire was being completed. Is that 1112 Garden Street?
That is correct.
All right. And how many people were on your team that day?
Off of memory, roughly, maybe we may have had 10, maybe.
And do you divide up and go to several places, or do all 10 members go to each individual location?
Yes, we were divided into groups of 2 to 3.
And where did you go specifically after leaving 1112 Garden Street?
After Director Blackwood and myself and Brent, we exited the structure. We discussed what we heard. It was then told to me who made what comments. We then broke off into multiple assignments. Got our assignments, set up our org chart and deployed. My attempt at that time, my assignment was to do a hasty search of the 1112 Garner's Creek property. I began around the house, and then my perimeter expands each time, looking for anything I could, that's out of the ordinary.
Did you find anything in the front yard?
In the front yard, we did locate a underground septic tank that was uncovered. That was noted. We then located the vehicles, of course, where they were parked. Yes. We located that. I then checked swing set to the left of the property. Kind of see a little dot there where your stick is. That tree line, there was a chain link fence that ran that length. We checked it, worked my way to the backyard, up around the dry creek, and then to the northeastern corner where you're pointing to a group of trees and bushes where I noticed a cleared area that's kind of like a little play area that maybe some kids would have played in a bushy area.
Did you observe anything in that location?
Yes, I did. Some disturbed ground and some vomit with appeared to be corn kernels and stuff in it, located in that.
Now, when you are on a mission, a search and rescue mission looking for a lost missing person, do you physically collect evidence such as vomit when you observe it?
That was not my role, and we do not. We allow law enforcement to collect.
But you did indicate that vomit in one of your sketches, is that correct?
Yes, it is noted in our first org chart assignment, and it is noted on the back in the rough sketch.
Where did you proceed after noting the vomit on your sketch?
From that point, I believe we cleared that area and reported back to where we started after we cleared that. And then we got another assignment. I believe that next one was over to the 1115 Garner's Creek. We checked it. Well, my assignment, yes. We cleared around that home. Same process from an inner circle to an outer. Looking for any types of tracks, anything like that, anything out of the ordinary. And then we met back up at the roadway, got a reassignment to the house with the red roof. We cleared that one along with that barn that is down to the bottom left. Yes, sir. We cleared that. At some point, I believe the dogs had picked up some type of track in that cornfield at the time. To your bottom left, right there. Yes, that was cleared. I do believe it was cleared by UAV also. My team was then redeployed to 1101. That home was locked. No one was home, but we did clear the exterior and the crawl space. By opening the crawl space, it was observed there were spider webs and cobwebs that had not been disturbed. That's a good indication that there was nothing had tried to go in. We cleared that barn to the southeast of it also. Nothing was observed there. We then reported back to command.
And at the time, was there a command post?
Yes, their command post was up there. Our unified command was located at the end of the driveway of Garner's Creek. There, that's where we set up our team's command post. Yes, sir.
The larger command post?
Yes, it was everybody. The TBI had their vehicle there. I believe Dixon County EMA had their command truck there, or rescue truck. Evening with Sheriff Bledsoe.
And when you arrived on scene at approximately 1 o'clock or whatever time, how many folks were gathered in this general area as far as search and rescue, emergency services, citizens there volunteered?
I could not tell you how many because it was countless. The time we arrived, of course, everyone, it seemed like in Dixon County and Middle Tennessee was there, along with law enforcement agency partners, local agencies. There was a dive team or water team in that big creek, that big pond, trying to search it. Yes, they had a boat in it, searching it. There's multiple ponds in that area, just on the northern side above the frame. Yes, above that. I mean, there were searchers everywhere: ATVs, motorcycles, skateboards, everything you can think of, just about. But there was multiple community members there, and at that time, everyone was under the impression that they are looking for a missing child.
Move the map as the next exhibit.
Exhibit 39.
Yes, sir. Mr. Bailey, you completed, well, first, can you identify this?
Yes, I can.
What is that?
This is our org chart.
What does that mean?
Through NIMS, we utilize this form of a chart to make assignments, to group people together for operations, to where it helps control and span of control. So you understand how many people, you know where people are, and people understand who they report to, and a chain of command.
Okay. I'm going to ask this to be displayed on the screen. So you called it an org chart?
Yes, sir.
And what is NIMS?
NIMS is it is a nationwide program that is based on the instant command system. It was initially started through out west from the Fire Association for the wildfire situation. It's a way to keep track of people and to run a command structure.
So on this, we have operations section, Barton County, search and rescue, Blackwood. Is Blackwood with TEMA?
He was at the time our director of emergency management in Murray County. He is now retired.
This says, what is this?
Our first op, that was the first mission we did, or the first hasty search that we did, they assigned us to.
What's this breakdown?
Team one, that was my team. I was head of it. Our assignment was to check vehicles, and then the perimeter, which just says vehicles on there, but we checked the perimeter and everything. Team two was assigned to the 2 outbuildings on the property.
And we're talking about 1112.
Yes, sir. Yes, sir. Their mission was that. Team three was team leader Henley and Gandy. They cleared the structure. Team 4 was a crawl space. It was Officer Ryan and Colton. They cleared the crawl space under the trailer or under the home. The next one was the perimeter again, was Officer Barber and Deputy Birdsong with the Sheriff's Department in Murray County. They cleared the exterior also. But it was almost like a redundant search with us. And then medical was Supervisor Doug Vineyard. When we deploy on any mission, we carry our own EMS with us, ALS support. In case something goes wrong with us, we have our people that we trust.
So this is a support position?
Yes.
Providing medical support to your team?
Yes, sir. And if something was, if the child was located, he would have been more like, if we found it, would have been first one there to help treat.
I'll move that as the next exhibit.
Mark is exhibit 40.
Mr. Bailey, can you identify that photograph?
Yes, I can.
What is that?
It is the upside down photo of the residence that was documented, the sketch, rough sketch, on the back of that previous page.
So it's the sketch of Operation 1?
Yes, sir.
Put that on the screen. Would this be Garner Street Road?
Yes, sir.
Look, I mean, this is obviously a rough sketch, correct?
Yes, sir.
Was it intended to be to scale?
No, sir. It is just to make a documentation.
And let's point out some of the things that you noted with this sketch. What is this?
That is the home, the residence.
What's this?
Those are the 2 outbuildings.
What are these?
That is the blue 18-wheeler tractor trailer, and the two in the pickup truck that contained bags of trash, and the red car,
What's this?
the open septic tank, or yes, septic tank.
And obviously, from my view, this is upside down. Does that say open sewer?
Yes, sir. Yes, sir.
And was that septic tank drained?
We did request through, I believe, the TEMA to request a sump truck from a septic company to respond out there to drain the septic tank in order for us to clear 100% that nothing was located.
And what's this say?
The swing set.
That's in the background?
Yes, sir.
Backyard?
Yes, sir.
And over here?
Where I located the vomit and disturb ground.
Does that say bushes?
Yes, sir.
And below that vomit?
Yes, sir.
Move that to the next exhibit.
Exhibit 41.
Mr. Bailey, let's go to your second mission. Can you identify that document?
Yes, sir.
What is that?
This is our second mission that when we started searching some of those surrounding homes.
All right, let's put that on the screen. Same kind of breakdown.
Yes, sir.
No need to go through it individually, but barn, house, canine, does that say creek?
Yes, sir.
And again, you got the medical person?
Yes, sir.
And second mission.
Yes, sir.
Move that to the next exhibit.
Mark is 43.
Can you identify that?
Yes, I can.
What is that?
Let me correct myself. 42 is the last exhibit.
This is the sketch, rough sketch on the backside of that previous page of the second mission.
So you have, again, is this the scale?
No, sir.
This is just documenting where you went?
Yes, sir.
It looks like multiple addresses, correct?
Yes, sir.
What's this address?
This is 1115. That would be the basement or the crawl space. No, the basement of that structure, yes.
Here?
That is maybe, I think he scratched it, but it looks like barn, maybe.
Barn?
Or something. I don't know what he wrote there. I can't tell. Boat. Maybe the boat. It was the boat. There was a boat parked in that driveway. That is the barn.
What's this?
Maybe kennel, maybe?
What about this address?
1108, the outside sweep. There was no one home. That was the house that no one was there.
What does that mean, an outside suite?
Of course, the doors were locked, so we're not going to make entry without permission, but we just check everything around bushes, behind bushes, under porches, under doors, anything that we think that anyone could crawl up under. You'd be surprised where kids would go.
And this address?
1101, again, that's the one that no one was home either, and we did the crawl space. That's the barn that I referred to that was in the back of it. That's on the northern part of the property, the area.
Move that as the next exhibit. Mr. Bailey, can you identify this document?
Yes, this is the third one, the third mission we did, or third search.
Put that on the screen. Third operation or third mission, and what is safety, Brian?
Chief Brian is our special operations safety officer. He is also the safety officer, training officer for the city of Spring Hill. We carry again him with us when we deploy on any mission. We try to, especially out of county, we try to take all assets that would support our team and our team only.
Move that as the next exhibit.
44.
Can you identify this document?
Yes, this is the sketch of the previous page, the backside. 1114, yes, sir.
1114, perimeter and crawl space.
Yes, sir.
So if it says perimeter and crawl space, does that mean no one entered the house?
Correct. No one was entered the house. Either no one came to the door, or no one was home, or we weren't able to gain access or get permission to search that property. So we did, but we cleared the outside and the crawl space.
Move that to the next exhibit. All right, and finally, Mr. Bailey, just to again kind of go over the different residences that your team went to. We have 112 Garner Street,
Yes, sir.
1108 Garner Street,
Yes, sir.
1114 Garner Street,
Yes, sir.
1115 Garner Street.
Yes, sir.
And I don't have this one labeled, but you testified you searched this.
Yes, sir.
And 1101 Garner Street.
Yes, sir. 1115 is where the boat was. That's where the boat was. Yes, the boat was in that driveway. I do remember.
I have 1 second. Pass the witness.
Cross-examine. For the city council to decide.
We've got a cubby hole around here that I made them all come back there so I could talk to them. But ladies and gentlemen, let me tell you, one of the things we were talking about is we're going to finish with this witness before we break for lunch. I know they're bringing lunch in for you. That may put us to 12:30 roughly or so, but that should work out all right with your lunch. We're going to probably quit at 5 o'clock tonight because you have to be relocated, as you know. So we're going to try to get that taken care of for you. The last thing was that one of you have asked a question of this witness, and that what is the approximate height of the mantle where the lock and key were located. I'm not sure that he knows, but I'm going to ask it for him. Do you know where the lock and key were located on the mantle, how high that mantle is approximately?
I can't.
All right, that's fine.
Sir, I'm sorry.
I think there may be other witnesses who can testify about that issue, so we'll just reserve that question. Thank you. Mr. Lockhart, you may cross-examine.
Officer Bailey, how many days did you work in regard to the search effort at this location?
I was there just for the first day on the 4th.
All right. And how many dogs would have been working that area that day? Do you have any idea?
From our team, 2.
All right. And what about other teams?
I can't speak for them.
Okay. And where all did your 2 dogs work?
I did not go with the handlers, so I do not know where they worked.
Did you see dogs working in the Daniels residence yard?
I didn't witness our team's dogs work the yard.
And what parts of the yard did they work?
They started a track from the back of the residence, and then they went on their own. I did not follow them.
All right. When they left, did they go out from the back out, or did one of the dogs go to the front of the house, in the front yard?
Again, I saw them start from the back, and then they went on their mission and had their assignment. I don't know. I did not follow them at that point. I stayed on my assignment.
So you didn't see, to your knowledge, a dog working in the front yard of the house?
Not to my knowledge.
Right. And did you overhear any conversations from the folks in the house about the amount of time that Joe Clyde Daniels had been missing?
I did not know.
And do you know if they discussed the fact passing indicates that the child could be dead?
I did not hear anything of that, no.
All right. And Mr. Daniels told you what he thought happened in regard to Joe Clyde getting out.
Yes.
He didn't tell
so.
you that did happen. He just told you that's what he thought might have happened.
He told me what he found and what he believed happened at that point.
And did you go over to the coffee table to see how easily it would roll on the floor?
No, sir, I did not.
Did you notice that the coffee table was on casters or rollers that made it easy to push?
No, I did not. I did not examine the coffee table.
And based on looking at the coffee table, would a child over 4 foot tall be able to stand on that coffee table and take a lock off the latch?
Without doing proper measurements, sir, I can't answer that question.
All right. Were you ever requested to do a search at a house where that same morning a mother had reported that her child's footwear were taken off her porch?
No, sir.
So no one ever requested you take a dog up there and try to pick up a scent from that area?
I was not responsible for the dogs at that time, so no, sir.
And were you ever requested to send people to that location and do a search?
I'm not aware of that, sir.
So you were not requested. I'm asking, were you requested? You said you're not aware. You would be aware if someone asked you to do it, wouldn't you?
I was not requested.
Okay. And by the same token, were you requested to either take people to or take a dog to a location where a lady said her little girl saw a little boy in dirty pajamas?
No.
If you had been requested to go to those locations and search and take dogs, you would have done so, wouldn't you?
If we were requested.
All right. The septic tank, you testified, was uncovered. And did you try to find out why it was uncovered?
I personally did not.
All right. And did you observe shovels at the residence that would have been used to dig the dirt off the top of the septic tank?
I did not observe any shovels.
The vomit that you saw was approximately how far from the Daniels residence?
Approximately maybe 200 feet.
All right. And did scent dogs, to your knowledge, were they used to pick up or try to pick up a scent at that location?
I do not know if they went that way or not.
Did you ask that the vomit be tested to see if a dog had thrown that up?
We passed that on to Sheriff Bledsoe and advised him what was located.
And would you have liked to known if that was a dog throw up or human throw up?
Yes, I would.
approximately when did they begin draining the pond?
I can't answer that. It was in process before we arrived.
Okay. And what would just everyday people think if they've lost a child and they see law enforcement draining a pond?
I can't speak for what everyday people would think, sir.
So you don't think adults would be worried their child was dead if they're draining a pond? They think their child was.
Mr. Locker was asking for his opinion, which he objected.
Well, I sustained an objection that the defense made to you asking him what he believed at that time, and I would be in fairness have to sustain this objection because I think that's the same principle. You're asking him to suppose what people generally would think, and I think that's an inappropriate question. Sustain the objection.
So you're not in a position to even give an opinion on that. Is that correct?
I don't believe I'm in the position to give an opinion on that, sir.
That's all the questions I have.
Redirect. Thank you, sir. You may step down, and I'm assuming we're releasing him from his subpoena, correct? You are released from your subpoena. Thank you.
Thank you, sir.
I believe that'll bring us to our lunchtime hour, so we'll go ahead and take our lunch recess. Let's be in recess till 1:15. We'll be in recess till 1:15.
All right,
Recording stopped.
this court is in recess.
Deputy Cox, when you finish, I need to see you.
Oh, sorry guys. I see that it's paused or out. Give me 1 second. I'll work on that. Let me know about the. Hey guys, sorry, I'm back. Let me know about this one.
And has different. It would have been after things that were initiated by the patrol division that did the initial response.
Okay. And then through the day, did other agencies begin to kind of filter in as requested to help with the search?
Yes, sir.
All right. Now, I've got a PowerPoint prepared. And before we get into it, you and I have gone over this PowerPoint pre-trial. Is that right?
Yes, sir.
And there's a bunch of agencies listed on here, and you've gone over those, and those were people that were on scene to help with the search. Is that accurate?
Yes, sir. To the best of my knowledge.
Sure.
I'm not
There was
sure
a lot
it's
of people
inclusive.
out there. Is that fair?
Yes, sir.
I believe at last count, there were something like 24 agencies from different parts of the state and the United States that showed up. Is that an accurate representation?
Yes, sir.
All right. So the main two agencies involved in this case was.
Is this a new one, guys, or have you seen this one before?
Yes, that's correct.
Go to the next slide. Obviously, we had several other state agencies.
Oh, is Blandino live?
What did the Red Cross do as part of the search?
They're tremendous with the support that they provide for.
Are you disobeying? Stop talking.
What? Oh, why are they a picture-in-picture? This is stupid.
Okay.
Well, guys, that's the hard part about these, trying to figure out which one of these day twos, because they don't break them up. But I'll just skip to day 3. How about that? We'll just start playing the day 3 ones from there. Fair enough. Yeah, I can't get my camera to work, guys. I'm sorry. Yeah. So I will say I will stick around for a couple minutes and we can talk and smoke a joke about this once he gets sentenced. Can you guys not hear it? Oh, hold on. Let me unmute it. Fuck. There. Sorry. Can you guys hear that now? How about that? Oh. Yeah, nothing they really talked about. But yeah, guys, right after this, I might just call it off for the day. I will start up day 3, and I will tonight make a playlist of all the. She's getting mad. So, anyways, just so you guys are here, I'm gonna take the Krystal Daniels one, and I'm just gonna make my own playlist, and I'll run it on my channel, and I'll just play it all the way through like that. How does that sound to you guys? Fair enough. And I bring that up because their playlists suck.
I mean, I understand what Dickerson said, that is to establish his intent behind it, but I feel like it's asking a bit too much. I would probably object on relevance plus potential character grounds.
But there were some real fireworks during the rebuttal argument. Mr. Blandino's the defendant in the case, got upset by the prosecutor's argument, and it really is very interesting. So I just clipped that portion out of there.
I want to thank Brittany and Alex Falcone of our Nevada Judges for their excellent video coverage of this case and many others. Welcome to episode 98 for Tuesday, March 8th, 2022. Blandino lost control and lashed out and threatened the prosecutor in front of the jury. I have to compliment Clark County Deputy District Attorneys Melanie Marlin and Michael Dickerson, who represented the state. In my opinion, they presented a solid case throughout the 5-day trial, and the closing argument by Prosecutor Marlin was top-notch, as was the rebuttal argument by Prosecutor Dickerson.
When he doesn't get a response back from Mr. Federico, and he ramps it up to the next level, he makes good on his threat. He makes good on his threat to expose Mr. Federico to disgrace by actually sending everything that he's already sent to the managing board of directors of this firm, all of his bosses. And what did Mr. Federico tell you about that? It was humiliating. It was humiliating. That's it. Mr. Blandino has committed extortion so many different ways in this case. Not just one. There's not just one avenue of extortion here. And it begins with Mr. Blandino. It begins right there in the note that he wrote on April 8th, 2019. I am ready to begin filing my complaints against you, indicating that it's for his courtroom activities, including violations of the code. He indicates that he's required by his religious beliefs and practices to give him an opportunity to negotiate.
Usually, by the time I get to court,
Please
I'm
let me
kind of
know
like,
within the next 10
cite
days,
resolution,
indicating how serious he is, because he's been
no,
affected.
it's the waiting
He's
in
been
between that
affected
really
because his
drives
last
you
two
crazy.
letters
Because you're like,
resulted in
okay,
letters of caution.
come on.
So
And then when I
please
get there,
don't take this matter
the
lightly.
whole issue of like when the judge has to do the thing, and they're like, everybody commanded everybody to, all those little bits and pieces. I'm like, yeah. Let's just get to the chase. But no,
This
generally
note doesn't
I get
say,
more,
hey, I just want to
frustrated
sit
when the
down
judge
and I
won't
want an
do it.
apology, Mr. Federico. Doesn't say that.
Although I really
It doesn't
want to know
say,
the argument
hey, I'm going to
of
file a
humiliating
complaint
this
against you
guy.
regardless, but I'd love an
That's
apology.
not emotional damage.
It doesn't
It's
say
not
that.
a legally recognized claim.
What it says
Extortion.
is I'm going to file a
This
complaint,
guy was embarrassed.
or we can negotiate. Extortion begins there.
So
then, when he doesn't hear anything from Mr. Federico, he goes to the Regional Justice Center. He told you that he was all around that day. He was all around. Yet somehow he walks into the courtroom still carrying his tray of stuff with his shoes untied from walking through security. And he told you that before he ever got into that courtroom, he looked right into it and he could see Mr. Federico right there on the bench. Okay. Now, he goes in, he sits down, he gets kicked out. Mr. Federico, in no unclear terms, in his capacity as a judge in that moment, says, you need to leave because you came to my private law office. Don't stop.
okay, yeah. So here, I'll talk myself right now. Yeah, Matthew. The worst part is for me is the waiting for a verdict.
Only he had said,
Not once a verdict's been
"Don't come back. I said, "I'll
reached.
touch you." That's it. Nothing
Um,
like that. Then
So
that would have been it.
that's the part for me that drives me crazy is the waiting game. But no, once it's happening,
There are no
kinda-
clear terms. Get out of the courtroom. Don't
it's also
stop
a
people.
relief because you know the
But
end's
what
coming.
does Mr.
So
Blandino
a lot
do?
of times I welcome a verdict. Cameron, thanks
Well.
for stopping by.
Now he's getting the reaction he wants. Now,
Hey, there's all kinds of Facebook, Twitter lawyers, jailhouse lawyers, street lawyers out there. So
Mr. Blandino
join the club.
is having fun. And if you
Yeah,
are
see,
having
he
fun,
keeps on
you
posting
aren't
that
doing it
video.
right. So now Mr.
You're
Blandino
not, having,
knows
you're not having fun. You're not doing it right.
he's on the right path.
He used those
The
words
path that
against
he
him. So
has
gotta be
set
careful what you
for
say.
the bond to see what he can get out of Mr. Federico.
So
he goes.
So yeah. Anyways, I'm gonna put a poll up. What do you guys think is gonna happen?
For
Can
whatever
you
that's
hear me
worth.
better now? I hope a
and
little bit.
Takes that and attaches it to a letter that he went home immediately and typed.
It's the only thing StreamYard does not let me do is
April
put a
25th,
poll up through
2019.
my
This letter.
thing here.
This is the letter that, once again,
That was the one part nice about Streamlabs, let me kind of do whatever the hell I wanted.
Michael Federico, in his official capacity as a judge pro tempore, as we discussed. The subject.
Oh, this shows
line
Kim
itself
Blandino now. Oh, I gotta stop.
indicates
I
what's
gotta fix
occurring.
that too.
The subject line itself indicates, I mean, it might as well say subject, extortion. Desire not to have to file formal complaint with Nevada Commission on Judicial Discipline. That's not how this works. If a judge is doing something unethical, they should just be reported. They should be reported. Anybody that's doing something unethical should just be reported. You, or Mr. Blandino, I should say, as a private citizen, anybody in this country doesn't have a right to dangle something over someone's head to say, you were unethical, now I own you? You committed a crime, now you have to do what I say? That is extortion. That is the purpose of this crime. And in this particular letter, Mr. Blandino discusses thoroughly.
Oh, you guys need to hear me? I'll turn my mic up. Oh, okay.
Started talking about.
Can't keep you guys
In
happy.
addition to identifying himself as a volunteer investigator.
Okay, how's that better?
On judicial discipline.
Hello. Also, this may suck because I'm using my laptop speaker or my laptop microphone. Hope you guys can hear me better now.
I came to your offices to see if we could resolve the complaint without having to use scarce judicial and Nevada Commission on Judicial Discipline resources. He indicates that he's done so with other misbehaving judges. And then he goes on. So to avoid having the Nevada Commission on Judicial Discipline subject the complaint to their protocols, I once again reach out to you to resolve this matter between you and I, or your attorney and I, if you wish to have an intermediary. You remember that whole argument defense counsel had about all Mr. Blandino wanting to do was to sit down with Mr. Federico? April 25th, 2019, he's telling Mr. Federico he doesn't even have to deal with him directly. He can have an intermediary. That's this whole sit down thing. It's not even a real thing. Because you take a look at Mr. Blandino's words, he didn't care. He wants to see what he can get out of Mr. Federico, whether it's Mr. Federico dealing with him directly or Mr. Federico's intermediary. And then, please know that I am very serious about following through to the best of strength that God gives me to do so. He indicates the sacrifice that I spend in time, inconvenience, and discomfort is very small compared to what they suffer to establish freedom and liberty based upon the very principles that God and His Son Jesus would wish for all on this planet to enjoy. The sacrifice that I spend in time, inconvenience, and discomfort I mean, definitely putting himself out to be a martyr. But if you aren't doing it, if you aren't having fun, you aren't doing it right. Doing it because he's having fun. And then
See where we're at here.
it goes further.
No, I don't think it's a clue to the verdict. I think they're just showing the closing when him freaking out is what's going on.
I gotta stop.
I had to guess.
Stop. No, I would ask, can you remind Mr.
Mr. Dickerson not approach this. I'm sorry. If he can say.
He's trying to talk to me, Judge. Purposely. He knows he's trying to talk to me. This is improper, and I'm making a bar complaint against you. I'm making a bar complaint against you, Mr. Dickerson. I will get these jabs, and I will make a bar complaint.
It's on your little business card icon. Oh, you mean the thingy right there? Yeah, you know what? Maybe I'll put them on there. I'll try to.
It's inappropriate for him.
I'll play around with StreamYard to get that sorted out. It's a good idea, miss. Just for you, that's a gold
You
star.
would not let me do that if I were representing myself. If I were going over to the prosecutor.
I was just asking, Your Honor, you give me, if he doesn't.
Because right now, also, that's a little more inspiring than watching
or listen to news or media accounts or commentary about the case and do research, such as consulting dictionaries, using the internet, or using reference materials, make any how it is completely and totally inappropriate for you to lash out and scream at the prosecutor while he's doing his closing argument. Totally inappropriate. If you don't like something,
I told my attorney 3 times that he cannot do that, and he should have
and you will raise it with the court.
He did not,
Okay?
and I had
He's
to raise
in
it.
the well. He can walk around in the well if he wants to.
When I had
I'm
my
not
stu-
sure
when
why
I had my
you-
trial in the 1990s, I tried to walk around and Judge Moffin, he said, you can't walk around, you gotta stand at the table. And you wouldn't have, if I were representing myself, you would not allow me to go over to the prosecution case. I know that for a fact, and if you're in your art, you have a different truth, you'd say that's true.
Well, there he is, Kim Spurgeon out again.
I'm sorry. I'm a little bit heated, I apologize.
Go for it, Kim. Lose your mind. Threaten him with the shit you threatened the judge with. That's gonna look good. Oh, here we go. It's about to start. We got the Amazon lady there. Where's High and Tight? Oh, High and Tight's there too.
I will. I'm sorry. I apologize, but if he can agree not to come over here.
No, he doesn't have to agree with you about anything.
He said he would just a minute ago.
He doesn't have to agree with you about anything. If you can't control yourself, you will be taken out of the courtroom.
I kept thinking about Las Vegas judges.
Conclude
I
with his
apologize.
closing.
I apologize.
Can you control yourself?
Yes.
Okay.
You know, if I just may, he's saying that I wouldn't make the objection. The third time he came over, he said, you know, I don't know what he did, he was turning or whatever to Mr. Dickerson, asked me to say, you asked him not to come over here, I was going to object or ask Your Honor to have him not approach the defense table because he can't seem to control himself and he's turning. So I was not, and then he just started looking. So I was intending to ask Your Honor if he could not approach.
Oh, here we go. Here we go. It's, as the Bruce Buffer says, it's time. The suspense is killing me.
Thank you, sir. Yep.
Wow, this is loud as fuck, but it's time.
Now in session.
Congrats on the UFC heavyweight division.
We do, and the defense?
Yes, Your Honor.
Fighting out of the blue corner. He's average citizen, completely full of lunacy. Standing 5'9" tall, weighing at 220 pounds.
Yes, Your Honor.
Has the jury reached
Kim
the
the
verdict?
Goldfish
Please
Blanding.
hand the
You
verdict
know.
form to Officer Hawks.
God, they are ready to go. Oof.
Okay, the clerk will now read the verdict out loud. If the defendant and his attorney will please stand for the reading of the verdict.
The District Court for our County of Nevada, State of Nevada, plaintiff versus Kim Dennis Blandino, defendant, case number C341767, Department number 12, verdict. We, the jury, in the above entitled case, find the defendant, Kim Dennis Blandino, as follows. Count 1, extortion, guilty of extortion. Count 2, impersonation of an officer, guilty of impersonation of an officer. Dated this 9th day of March 2022. Signed by foreperson Anthony Romero. Ladies and gentlemen of the jury, is this your verdict, so say one, so say you all?
Okay, does either side wish to have the jury panel poll? Mr. Dickerson?
No.
Mr.
Wow,
Dickerson?
he's keeping his shit
I don't know
together.
what it is, but yes, Judge, I'll ask you.
Absolutely. At this time, ladies and gentlemen, the clerk is going to ask you a question, and you just have to respond yes or no.
Juror number 1, is this your verdict is read?
Yes.
Juror number 2, is this your verdict is read?
Yes.
Juror number 3, is this your verdict is read?
Yes.
Juror number 4, is this your verdict is read?
Yes.
Juror number 5, is this your verdict is read?
Yes.
I'm sorry, it's going to be Miss Susan, or, I don't say your name. Thank you. Juror number 6, William Luke, excuse me, is this your verdict is read?
Yes.
Juror number 7, is this your verdict is read?
Wow, they're using their names like that. Wow, wow, wow,
Juror
wow.
number 9, is this a verdict?
You
is
can't
read?
do that.
Juror number 10,
Oof.
is this your verdict is read?
Yes.
Juror number 11, is this your verdict is read?
Yes.
Juror number 12, is this your verdict is read?
Yes. Okay, at this time, the clerk will record the verdict in the official record of the court. And at this time, ladies and gentlemen, you can have a seat. I am going to discharge you from your duty as jurors. You are no longer to discuss the case with anyone. You're free to discuss it with whomever you want. However, you're under no obligation to discuss it with anyone. I am going to excuse you to go back in the jury deliberation room where you will get further instructions. And then you will be excused to go. I do always like to give the attorneys for both sides the opportunity to talk to the jury panel, but only if you want to. Both sides do try to use the law in this courthouse, and I do think it's good for them to speak to a jury panel afterwards, to see what you liked and didn't like. I think it makes them better trial attorneys. However, it's completely up to you whether you want to talk to either side. But before I do excuse you, I just want to extend my gratitude to you for your willingness to be here, especially if you went a couple extra days than what I told you, and I want to thank you very much. You're very courteous.
They stuck around for the free lunch during their deliberations.
I really appreciate it. So at this time, ladies and gentlemen, you are discharged as jurors.
Thank you. All right, so that's your jurors. If you'll please go with Ms. Osterman. Thank you, everyone. Please be seated.
The record will reflect that the hearing is taking place outside the presence of the jury panel. Mr. Dickerson, do you want to be heard?
We would like to be heard, Your Honor.
Hold up, Bond.
Motion of innocence is gone. Mr. Blandino has been found guilty by a jury of peers. He's no longer entitled to bail. We would ask that you remain today.
Ooh. We're getting spicy, kids.
And Your Honor, we would ask that you allow him to remain on his bail and allow him to on bail and his his ankle bracelet, electronic monitoring. He is local here to Las Vegas. He is not a flight risk. He is the caretaker for.
Hey, does that take care of the echo, miss?
In the courtroom here today. I think that he certainly needs an opportunity if he, awaiting sentencing, to be prepared and to have any affairs in order that would need to be in order for a sentencing date. But again, he is not a flight risk. He has been.
You have 4 cases going right now. Jesus.
Issues on being on electronic monitoring. I believe
That's awesome.
he is on medium level. If Your Honor would feel more comfortable, perhaps putting him on the high level electronic monitoring, and that he would be here. He's not going to miss any court date, and like I said, he's not a flight risk. He wants to come to court. Mr. Dickerson alluded to this is fun for him, and so I don't know what else to say. He's not going to miss any court. He has been and on the electronic monitoring. You know where he's at. He's not any threat related to the community. He hasn't been for the 2.5 years he's been on. Yes, I did forget. He did have the 2-week absence in December where he went, we allowed him to travel to his son's graduation, and he was off the ankle bracelet. No, he's coming back. He's back on the electronic monitoring ankle bracelet. So I think all that demonstrates that he is a candidate to remain on his electronic monitoring and will be here at any future court.
The state of Nevada has to disagree. We have to disagree about him being in a position at this point in time where he wants to come back to court and be in a position where he's still having fun. Mr. Blandy is no longer having fun. Mr. Blandy is no longer in control of the situations. We've seen throughout this case what Mr. Blandy has done is not control or feels like he's losing control. He obstructs. He refuses to cooperate, including when he was ordered to get testing, psychological testing through Lakes Crossing, before Lakes Crossing, for that matter, Your Honor, by his court. He refused to cooperate with that. He then was forced.
Yeah, it's a little offensive to get forced to be told you're insane.
Because of his obstruction and refusal. Then throughout this case, off the top of my head, I believe it's 22 motions to disqualify the courts that were solely for the purpose of obstructing and harassing these proceedings. Whenever he was feeling like he was no longer in control of things.
Oh, come on. You deal with hardcore guys, and you're going to get your tampon all twisted up over this. You're being a little girl, Dickinson.
We've seen his behavior here in court. We've seen his disrespect for the law. Mr. Blandino does not respect the letter of the law at all. He doesn't respect court orders. He's violated this court's orders in the past. He's violated past court orders, even indicating in some paperwork that he's going to go do surveillance at the named victim's residence in this case. That is incredibly concerning to the state. I would also note that he is a convicted felon. In that particular case, which is also of concern, he fled the state of Nevada with his children that he kidnapped, changed their names, told them that their mother had spiritual cancer and that she died. This is an individual who has...
A lot of people on the internet have spiritual cancer.
To be remanded pending sentencing, and I think that the state of Nevada will be in a good position to also...
I like that, spiritual cancer.
Regarding evaluations prior to sentencing as to his...
I'm pretty sure I have that.
...happening with him at the time of sentencing.
If I may speak to the, as to the, I would stand by counsel at that point. That was in competency court. Honestly, there was a discrepancy and a misunderstanding.
Sorry, I'm at my office, so people are in the parking
lot. The appointment
lot.
had to be set, or the evaluation had to be done by the date certain. Mr. Blandino is not well liked. He does not get the benefit of the doubt. You know, and I'm not a witness, but he did set the appointment. He did not have it as far as disobeying the orders for his evaluations. This was in December around the holidays. He was not when that happened. So I don't think that is what happened, that he was willfully disobeying those orders to be evaluated. Like I said, it was difficult at that time to get appointments. He did set appointments. And so as far as that is concerned, I don't think that should be counted against Mr. Blandino for disobeying the court. We heard testimony, Judge, from the detective after doing the search warrant. There was nothing that indicated he was a threat or a danger that led to additional charges and all those papers and all those files or anything like that, that Mr. Blandino was a threat. So I think he, if he's on the high-level electronic monitoring program and he's on bail, so he's got he's got the jail who runs the electronic monitoring program, he's got, private bail company with their bounty hunters. He is not a flight risk. He is not a danger. The high-level monitoring, they have strict curfews. They have strict rules about when he can go, where he can go. Since he doesn't, I don't think he has he doesn't have a 9-to-5 job, I'm trying to say, so he can't really go anywhere during the day. And also, as far as filing, obviously he's a vexatious litigant. He can't file. When I was standing by counsel, my understanding of my role was that, he was the attorney and I filed these things. Obviously, I've said it before. Clearly, I filed things as standing by counsel, but I would never file as an attorney. So I don't think that that's an issue of him filing anything here with the court. So, because that would go through me, I will not file anything that would be, I can't imagine anything that would need to file, but certainly none of the.
Raven Girl, hello. Wow, there's new people now.
Like along the lines of what was filed, the motions to disqualify, any of those things, I will not file that or anything like it. So I don't think that's a concern either.
I would note one thing regarding it being brought up that the detective testified, there's nothing of concern about being.
Filing all the motions has nothing to do with disregarding the court. The guy
didn't want to get into all the other things that have been found during the investigation to be not prejudicial. That it includes the fact that Mr. Blandino, even after he was charged in this case, continued this same behavior, including to the Justice Court Pro Tem Judge Leah Williams, who sat on his case in this same case in Justice Court before he was indicted, where later on, after his indictment, he sent her the letter that we discussed in the hearing outside the presence of the jury in November of 2019, indicating that she needed to recuse herself from a civil case that was before the Justice Court that he believed that she was the judge of, and that if she didn't recuse herself, he was going to be filing complaints against her with the Nevada Commission on Judicial Discipline. That letter, too, he took up to her private law office and dropped it off. His criminal behavior has continued, Your Honor, and it's time to put it to an end.
Is he a party to the civil action?
He believed that he could be an intervener.
He was not a party.
He was not a party.
Because I'm not, I guess I can't speak to that, to civil matter. I'm not able to speak to that. I don't know about it.
Can I say anything?
No.
Okay.
No, represented by counsel. So at this time, I'm going to allow him to stay at liberty pending sentencing. His monitoring will be raised to high level electronic monitoring. All of your conditions will remain the same. So you understand you're not permitted to have any contact with the victims in this matter.
Right.
And you're not permitted to send any letters of the kind that you, in this underlying matter.
Can
You
I continue
understand
to
that?
file complaints to the Commission on Judicial Discipline now? And they'll do the ordinary course?
I would ask that anything that he's going to file, any complaints or anything like that, should go through his attorney, Your Honor. At this point in time, we know that he's
That's
using.
a very good idea.
So I send them to him and then he clears it?
That's correct.
Okay.
Right, and then you won't have any issues, because if you have any issues pending sentencing, you will be remanded pending sentencing.
Okay, understood.
Do you have any questions about what your conditions are?
Stay away from Nordstrom, stay away from Federico. No filing Commission on Judicial Discipline with the complaints except for him. Now,
No sending people
okay,
letters.
now one thing I do have, I tried to file, or serve Mr. Federico, and my son tried to. I gave it to legal wings this morning because I didn't know if I was going to remain it. So a third party will be serving Federico at a federal civil rights suit. And as you know, we're supposed to try and negotiate or try to resolve it without going through the trial. So how do I handle that?
Have any contact with Mr. Federico.
Well, how do I handle that with the federal court?
Do not have any contact with Mr. Federico.
So if I had.
Okay, I mean, I just want to make sure, I don't care what litigation you have going on, you get an attorney, you get somebody
So if I
else.
get an
to have
attorney
the
and contact through the attorney, it's okay.
That would be fine.
Okay.
But you cannot have any direct contact. He clearly does not want to have any contact with you.
Well, yeah, but I'm not allowed to file federal civil rights, and that's what I
You
did.
sure?
Yeah.
So with that, we would also request, since you're going to be leaving Mr. Blandino out of custody, we request an overall order that he not be at the RJC or the property of the RJC unless he's here for a case where he is a party for an actual court appearance, and during that time. We also wanted specifically that he not come to any of the offices of the Clark County District Attorney's Office. During the course of this case, it's come to my attention that Mr. Blandino has visited our reception at the Clark County District Attorney's Office, caused the women working there to feel very uncomfortable, started yelling at people in the lobby or harassing people in the lobby about wearing, as he calls them, diapers on their face because they're wearing masks. It's something that is of concern to our office, and our investigators are aware of it. He is not allowed at the District Attorney's Office as far as we're concerned, and I've told him that he's trespassed.
Okay, do you understand that? You are not permitted to come to the RJC for
Right.
any reason unless you have a proceeding here where you are the party.
Now, does that
Do you
include
understand
if I have to go to the clerk's office because the computers are down to file something or that? How do I do that? I have to mail it?
You're just trying to talk me out of letting you stay at
No,
home,
I just
aren't you?
wanted to.
I mean, I literally feel like you're trying to talk me out of allowing you to stay at liberty.
Okay, no, I appreciate it.
Yeah. Just some clarification, with whom do I, if he has the complaint that he sends to me, with whom am I supposed to clear that? With Your Honor, with Mr. Dickerson? I just want a little.
No, you use your discretion.
Okay, perfect.
Yeah, I mean, you're an attorney.
Yes,
you're an
okay, I
officer
just
of court.
want to make sure that that's what the
Absolutely, so the
criteria was.
the matter will be referred to parole and probation. You understand you're gonna be required to go to parole and probation. You're gonna be required to participate in an interview. Do not let that report come back to me saying you refuse to participate.
What do you mean for the PSI report?
That's
But
correct.
I go to the jail for the upgrade on the high level though.
That is correct.
So it's two separate things I'm doing. Parallel
That's
tests, okay? All right.
But again, I just wanna make sure you understand you have to go to parole and
You
probation.
got a report date for me?
I have paperwork for you.
Okay.
My suggestion is you go within the next 48 hours.
Oh, that's no problem there.
So that they can make sure they get it done, the interview, and prepare the report and get it to the court on time.
Yeah, do I have to make an appointment with them or can I just drop in? I don't know.
You're gonna be given paperwork, just.
Oh, okay.
I
Let the
believe you
judge
can
finish.
just report to PNP. I don't think you have to make an appointment. Okay?
Sentencing is going to be July 7th at 8:30. If we're still on pandemic schedule, that will be at 12 p.m. And Marshall, here's paperwork to be placed on high level. Oh, and
I'm sorry, Madam Clerk, what was it, July 7th?
July 7th at 8:30. If we're still on pandemic schedule, that'll be at 12 p.m.
One thing slipped my mind, and it's the fact that the municipal court, which has been the target of much of Mr. Blandino's ire, has now moved to a different building. And so we would also request that the stay away order include the municipal court, unless he has the same thing, a case that is on calendar that day, that'd be cool.
I don't see that's out of line.
Okay, so I'm gonna include, because the Las Vegas Municipal Court, they used to be in this building, now they have their own. So you understand you can't go into that building
Okay, yes.
unless you have a case on calendar wherein you are the party. Do you understand that?
Yes, I do. Thank you.
This might be premature, but I just want to say that, or put the defendant on notice. I do not do appeals. I do not do appellate work. Mr. Blandino has filed things alleging and about my ineffectiveness, and so obviously I'm sure that if an appeal were to come of this, that would be an issue, and I would not be handling that appeal. Mr. Blandino, quite frankly, probably has more experience with appeals than I do. But I would like to put on notice now, I will not be handling any appeal, I will not filing any notice of appeals on his behalf.
Okay, so it sounds like Mr. Bateman's gonna ask to withdraw as your attorney of record after your sentencing.
Right.
So you understand you have 30 days to file a notice of appeal?
Well, after a judgment of conviction with sentence, I can't appeal no, but that's just,
That's correct.
right.
That is correct.
Although they allow a early thing.
So if you want Mr. Bateman to help you with the notice of appeal, he may, but I'm assuming you're gonna want to represent yourself on appeal.
Well, they're under Blandino versus State, which is named after me.
Is that a yes? Okay, I'll take that as a yes. Okay,
Yes.
anything else?
Thank you, Judge.
Thank you.
Thank you. Court is now in recess.
Can you guys hear me now? Can you guys hear me now? Okay. Yeah, sorry, that's weird. StreamYard gets all stupid once in a while. Also, did I just kind of inception myself? I think I might have. Whoopsie doodle. Oh well, screw it. I'm already here now. So, anyways, guys, just for those of you new, I wanted to introduce myself. My name's Sean Martin. I'm an attorney out of Northeast Ohio in the Cleveland area. I do criminal defense work. I like covering criminal stuff that comes my way. So Raven Girl, Ash, anybody else that's new today, hi, welcome. Welcome. If you guys like what you see, please like and subscribe. I'd appreciate it. All that stuff goes a long way. But yeah, that was it for today. I thought I'd cover it. Today, I'm actually working in my office, so all the wonders of it is right now in my office right here. But normally I do them from home. So if you watch some of the other streams or some of my videos and it looks a little more fun or interesting, that's why. But yeah, today I was getting a lot of work done. I had a couple of court hearings, so had to meet a client over at the jail. But yeah, I generally try to have I'll stream cases. I like to do videos of my own. If you guys click through, you'll see some ones I've made. I try to do that. We've been doing a stream every Thursday night. So tomorrow night, 9:30 Eastern time, we'll be doing it. Sadly, one of the cases I wanted to cover just got postponed, and I was hoping somebody would get sentenced in it, but I'll mention it tomorrow. Yeah, and if you guys like what you see or hear, like I said, like, subscribe, tell everybody. Let's try to. Jeez, I think we got a wreck down the road. I'd like to steal all law and crimes client or all their viewership. Also, if you guys ever have ideas of your own, I generally try to put my email address in there that I do off this. Shoot me one on Gmail and say, hey, this. If it's something in your area and it's something we can watch, might be down for it. It might be interesting, might be cool. So yeah, just wanted to give that rundown to all the new people. Thank you, Shannon. I appreciate that. Well, Miss, can't hear you now? Oh, I was about to say, I'm like, everybody else is like playing mind games with me. So no, that was a, at the end of the day, yeah, that's not a surprising verdict. It's probably the correct verdict. He kept his shit together, which I'm surprised about. So the judge set out a bunch of terms. It sounds like he's got to go for a PSI, pre-sentence investigation report. Well, Matthew, you can mail me too. If you guys have any issues, I'm serious. You might have a cool case to talk about. And if it's not something we can live stream, maybe I can cover it afterwards or do like a recap of things. Also, if you have questions about a case or criminal stuff, there's no such thing as a stupid question. If I can answer it, I will. But yeah, that's a pretty standard sentencing. Now, yes, generally speaking, once you've been convicted, your right to bail is pretty much gone, but the court can grant it. And with that being said, a lot of the reasons the state brought up, I thought, were chicken shit. For example, that he filed a bunch of motions. Okay, great. He's a nutbag, but is that hurting anybody? It's paperwork. A bunch of those I thought were chicken shit. How they did it. We'll have the Makabuna trial. I'll have to look that up when we're done here. Actually, Lori, can you shoot me an email on that? And also, Critter, I need to talk. I'll send you an email because I want to talk to you about something. But yeah, that's what I generally try to tell my clients, and just so you guys understand, what happens post conviction or post you've been a jury finds you guilty, but prior to sentencing, this is like a job interview, and the interview is, are you good enough to be on probation? These are probationary offenses. I looked already. These are not mandatory prison terms. So this is a potential probation case. And part of this is he's been given a list of things, and can he abide by them? Well, maybe he can. And if he can, then he might actually be able to follow the rules on probation. So if you ever know somebody who gets on probation, tell them, treat it like a audition for, post-conviction release. It's a job interview. You're showing the judge you can follow the rules. Now, there's some things on there that make sense. He's not allowed to go talk to the victims or show up at their places of work. And those parts make sense. But it sounds like he was waiting to file a federal civil rights lawsuit. And she said he can't do that because that counts as contact. And if he does want to do that, he has to use an attorney. I don't know if that's legal. I would just say from the standpoint of, if you can't afford an attorney, then he can't file his suit, but he has the right to file a suit. So that's one I kind of have an issue with. I don't know if that's actually enforceable, or is that a legal condition the judge can set? Because that's kind of outside our jurisdiction. Now, yes, Road Dog, you bring up the point, or Miss, his past convictions. Yes, I was going to get to that. When you determine whether or not somebody's going to go to prison or not, everything becomes a factor, and prior convictions increase your odds. The way I explain it to people is, every time you set foot in a courthouse, your odds of not walking out of there go up. Actually, hold on, you can see here. They go up and up and up and up and up and up and up. So, yeah, if you end up with a bunch of misdemeanor charges, eventually you're going to start going and you're going to get screwed. Eventually you'll get a misdemeanor charge and you'll go to jail for that. With your felonies, it's that the odds of going to prison on felony charges go up and up and up a lot quicker. But, if you have like one felony on your record and it's some low-level stuff, okay, fine. It was like 10 years ago. You're probably okay. But remember, your odds are still higher than some guy who doesn't have a felony conviction. So yes, these odds go up, 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 and up from where he was compared to everybody else. So it's just something to think about, and you are correct. All of that can happen. What makes this channel great? Interaction. FSU professor Murder Garcia. Reach on stream. You can use this. Okay, so he killed some. I gotta. Mac. Buwana. I'm gonna have to look that up later. So somebody got hit and killed. Okay. So yeah, but the rest of those things make sense as far as any issues that go on. But yes, he just couldn't accept yes for he couldn't just say yes, judge, I will do this. Well, like you said, like the judge said, you're almost talking me out of this. So yeah, if you're ever in court, and I know you guys are probably less smart than Kim Blandino, but when the judge is telling you what your conditions of bond are, shut the fuck up and just say okay. Now, if there happens to be a situation where his attorney brought up that, wait, you're making him report to go do something, he may run into people, you have to point out if that's going to be an issue. Don't be afraid to say that, and then let the court straighten it out. But yeah, other than that, I mean, those are pretty standard terms of, release pending sentencing. And the way your PSI works, it's the way I try to explain it to people. It is the story of you. Because all this judge has is a file, and that file is the case in front of her. Now, she may have learned a lot about Kim in the meantime, but she still doesn't know everything about Kim. Everything about him that brought him to this point, everything that brought him here to her right this second. And she needs to know that to make a proper decision on how to sentence him and what she should do. So that'll get all filled out. He'll have an opportunity to kind of say his piece. If he's smart, he will probably try to have some level of contrition in his pre-sentence investigation, because they usually do involve that. And we'll see how he does. Now, if he doesn't comply, that's going to be a problem. If he gives them any shit, it's going to be a problem. Well, Matthew, his attorney was pointing out to him, because a lot of people actually do have this issue. When I've been appointed or retained, they ask me, can I do appeals? And sometimes they think I'm automatically doing their appeal. And that's not how that works. But he's saying that for the record because this guy's, Blandino's crazy. He's a spaz. So he's doing that just to cover his butt in the formalized sense. Also, he doesn't need him to try to say he made promises to Blandino. He also doesn't want Blandino trying to sue him later on down the road saying, you didn't provide me counsel, yada, yada, yada. If this was a normal client, he wouldn't say that, and it would just be made clear. Yes, I would have said it as well, that I want to make it known I am not involved. If he does want to, he should. And that way, I will give his attorney a lot of credit. His attorney could have saved that till the day of sentencing, and then giving Kim 30 days to get it out, figured out. He actually gave him a heads up right now. If you want to appeal, it's not a bad idea to start looking. That said, though, appeals are expensive. If he can't afford an attorney, he'll have to ask for one to be appointed for him. If he could try to hire one, I mean, on a case like this, it's probably going to be an extensive appeal. You're looking at probably, for me to do it, I'd probably charge like $7,000, $8,000. And that doesn't include probably about the $1,000, $1,500 worth of transcripts that he's going to have to pay for that come out of his pocket. And that doesn't come out of mine. That's a separate fee he's going to have to pay. Now, if he can't afford any of that, I assume he'll probably get court-appointed counsel. That'll be provided to him at no cost. But yeah, there's also the issue of if you... he could say he's going to represent himself, and he could file as an indigent person. And he could claim he can't afford it, and they could still provide it to him. But the other thing to point out is his attorney, you can't represent, generally doing the appeal for the case you defended is bad, because one of the things you argue as an attorney when you're doing an appeal is ineffective assistance of counsel. You're going to argue, hey, this other guy sucked really bad, and, oh, sure, tell me about it. If something, we may talk about that. One of the videos, and this is something I wanted to float by you guys, kind of like a show of hands. because people do bring this up and it's a discussion to be had. Are plea deals ethical? Is that something we should have in our system? Are they wrong? Do you think they're abused? There's plea deals are the way people, some see that as a way the justice system gets convictions, in a secret way without having trials. So let me know if you guys, because that's some stuff I want to talk about, kind of more of the, kind of like the philosophical topics. Are plea deals ethical, and should we have them at all? So just let me know what you guys think about that. And, you want to say yay or nay, yes, no, because engage interest. But yeah, part of it is you have to argue ineffective assistance of counsel. In his case here, I don't know if he's going to, because it sounds like he directed his attorney and his attorney pretty much did what he wanted. So I don't know if he's going to have a lot of grounds there. He's better off just arguing, like manifest weight of the evidence, some things like that. But oh yeah, I mean that does happen. There are people, certainly, and that is an issue with any system where you're determining guilt or guilt based upon people having to make decisions. There are going to be innocent people who have been wrongfully convicted. But yeah, all you new guys, don't be afraid to answer questions. Ask questions too. I know looks right now I'm kind of talking with the old guard, but don't be afraid to jump in. Seriously. All right, so I'll work on that then. I'll work on putting that together. Yeah, actually, hold on. Somebody coming in? Sorry, I was looking at the window to see if somebody was coming in. But yeah, this is Kim's chance to show the judge he's not a complete turd. I have a feeling he's gonna fuck this up. I mean, let's be real, he probably will. So yeah. I mean, there's no other way to say this. Oh, and I forgot to mention earlier, I know somebody saw me drinking something. No White Claws today. We got to keep it honest, so. Geez, when you guys don't, normally you guys are just like, bah, 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 bah. And then when you guys don't for a second, it makes me think things are frozen or something. Sure, I'll be happy to hear it. Send it to me. Oh, he probably will be in custody before then. And if he fucks up, he's going to prison. I don't see how he doesn't. Because if you can't follow the rules, then most judges are going to ship you. Hi, Hellcat. Welcome. If you've been here for a while, I apologize, but I haven't seen your name pop up. Yeah, that's really it for me, guys. This is that was very anticlimactic. What did I think of the testimony today that I watched? I was really only able to watch bits and pieces, so I am sorry, miss. I did not. I mean, I still I switched out of my work shirt into a t-shirt just because I was a million degrees over in the courthouse. So, I mean, I still have my suspenders on and everything. I don't know. I just was checking it every once in a while, and I was like, "Oh, stuff didn't work," and boop, 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 trying to fix stuff up for you guys. So yeah, I don't have much to say about this one. I don't know if I will, because it sounds like it's pretty obvious. Like I said, my one for Krystal's gonna be interesting. I think that one's really gonna be a interesting one to do. An interesting one to follow. I think that one will be easier to follow because I'll be following it from the start. Okay, yes. See, thank you, Lori. Just that way I can figure out what it is. And then I'll go from there. my homework tonight. I got a lot of homework. I got a 1,500-page PL I've been chipping my way through. So I got enough homework already, and I just got a whole set of controlled buys on a guy slinging some heroin and fentanyl. So I'm a little busy on homework right now, miss. I'm like working my way through some stuff right now. Yeah, God, I feel like I'm stealing all Long Drive's people. Great. Dan Abrams going to come begging me to stop soon enough. He'll be sending me a cease and desist letter. And I'll get to tell him to fuck off too. It'll be great. Just my opinion. Hey, it happens. Also remember, it's in Florida, so because Florida is a very valid answer to reasons why things happen. You know, Florida man did not just come out of someone's mind. Florida man exists for a reason. Oh. Sorry, I just got an email. I gotta see what the fuck this is. Oh, what the heck? Oh, so yeah, I'd love to see him believe you get a year to $5,000. Oh yes, I could see. I don't know if Blandino said that, but I could see him being the type of guy to say, things happen when I get angry. I've had people say that to me before. I think I said to me in my office once, "You won't like it when I'm angry." I'm fucking scared, bro. Yeah, you do you. So hi, Christopher. I don't think I've seen you before either. Hello, welcome. Please like, subscribe if you are interested in what I do. So I'd like to see Blandino get a year and a $5,000 fine. Why only 364 days? Was he impersonating a sane person? Oh, Vile, that's what Joseph Daniels said. Well, yeah, I'm sure he'll be rough and tough and tumble like that when somebody on the tiers is charging him rent for his fucking cell. Hope he has fun with that. Oh, that's the limit for really? Huh. 364. That must be. Yeah, Nevada's got some weird rules then. 364 days, but okay. You remember though, anytime he served in jail too, so far it eats into that sentence. So I think it said he served like 100 days already, maybe. So that'll eat into things. But yes, artist, who is he impersonating? A sane person? Yes. He was impersonating somebody who has his shit together. But yeah, I have dealt with sovereign citizens, and I've dealt with people like him. And there's a lot of people who are like him that aren't sovereign citizens. They just are YouTube lawyer. Well, shit. Shouldn't say YouTube lawyers because I'm a fucking YouTube lawyer. Okay? But look, and you guys know this, I actually know my shit. I'm a real lawyer. Like, no, like Twitter lawyers and Facebook lawyers. If you've been in the military, they're called like barracks lawyers. Yeah. There are a lot of people who are so sure of what it is they're doing until they walk into court. And, you know, I was, actually, I want to show you guys something because I do have a great example of what happens generally when pro se clients come into court and they think they're doing the right thing. Um, um, oh, okay, I remember now. I got this set up. Hold on. Let me see here if this shows up. Oh, hold on here. Put it on your honey-do list. Well, hold on. What's going on my honey-do list here? Yeah, he's not gonna get the full 10 years. I mean, was this extortion? Yeah, but is this like, give me money or I'll fucking kill you type extortion, or I'll burn your store down? No, I mean, generally, like, and Christopher, you're right. I mean, but think about it, guys. When you think of extortion, you're thinking of like Vito and, the other Goombas and the mob. And I could say that because I'm part Italian. So I can use that word. I can't use the pro gamer word, but I can use that word. Yeah, this isn't the typical thing of extortion or intimidation, because generally it's like, judge, change your sentence or I'll kill you or kill your family. Not, I'm going to report you to your manager. That's a different level. This kind of fluctuates on whether or not, I guess think about it this way. If Kim Blandino wasn't such a dick and a piece of like just complete lunatic batshit period, do you think this would have been charged? I don't know. I think this is kind of on the edge. Yeah, he can face up to 1 to 10 years with a $10,000 fine. A lawyer represents himself as a fool for a client. Sometimes. I will always say there is a famous politician named Jim Trafficant. He was a representative out of Ohio, out of Youngstown. And if anybody here knows about Youngstown, it's kind of like The Wire meets The Sopranos. Was a corrupt hellhole. He was the sheriff and was on trial for RICO charges. He is the only man in history to ever defend himself in a RICO case and win. So every once in a while, somebody can knock it out. So, like I said, guys, I think it really depends on, what you're doing here. As far as like, is this extortion in the sense that we think of extortion? No, but is it enough? Okay, here, hold on. Yeah, I think I found the thing I wanted to show. No, where's the thing where... I mean, and I don't know if that's a fair thing. If you guys disagree as to what happens, I understand, and I'm all for listening to hear what you have to say. But I just don't necessarily think this is the worst of all. Oh, you leaving yet? Oh, sorry. Well, have a nice night. Am I wrong, guys? Do you disagree? Like, this isn't the typical... I mean, he may be a dickhead and a tool, but, do you guys honestly think he deserves 10 years in prison? I mean, like, 10 years in prison is hard. You got to earn that. And I think, you just need to be careful. So anyway, where is? Okay, yeah, here we go. I think he gets 2, and I think that's fair. I think that's a reasonable thing, Christopher, and I would agree. But like I said, I just want to make sure everybody here's not on the thumping the drum. We need to make him go brick rocks. Like, there's got to be a little proportionality, because how many other like hardcore criminals are getting full time? Anyways, guys, this is my best example of what it's like when, Matthew, you said it best. Generally speaking, when you come into court on your own, here's generally what happens, in my opinion. This is probably the best example of it. And I'll probably play this tomorrow when we have everybody here. Anyways, but yeah, this is a great example.
Offensive linemen who average about 320. So our 160-pound lab rat is clearly in way over his head.
Oh, see you, Christopher. Thanks for stopping by. Like I said, like, subscribe, appreciate
all
it.
the average Joes out there
Get notified about when I
appreciate
come
this,
on
'cause
again.
I'm about to get my bell rung.
Let's do this. Time to find out how an average guy would try to stop an elite NFL defensive lineman.
That's pretty much how I try to tell people what, when they go to court and defend themselves, is like. So. Yeah, but that's I remember explaining to my ex that I'm really that much better at Smash Bros than he is. Hey, do the old school Smash Bros. I'm all about that. Even the new one's not bad. Yeah, there are just skill gaps. Well, there's skill gaps and there's gaps you will not be able to. And you know what? You could probably close that gap given time, but the amount of time you'll need to close it will not be soon enough for your trial or your case period. Now, if your case was going for a couple of years, you might be able to catch up. Yeah, but here's the problem. If you let him go pro se, that creates issues on appeal. And she didn't want to turn it into a circus, and she didn't want to go forever. Now, forcing him to have an attorney, that and she didn't want to deal with the appeals. But I guess my issue with that is, if I'm sitting there, is you don't want to deal with the appeals, then I don't know, quit being a fucking judge. That's if he wants to hang himself like that in front of everybody, that's his problem. Her doing that, I don't think is proper. He does have the right to do what he wants. But yeah, keep the guy in the back burner in case you need him. So, and I understand that, but there's a thing, like I said, and you guys have probably noticed this to an extent. Judges are risk averse. They don't want to make waves generally, especially in criminal stuff. Now, a judge may make waves on a civil trial, but that's different. So. Well, guys, hey, I hate to cut it short, but I got to get some things done, and then I got to drive back home. But I will get this set up for tonight, get some playlists going, and then tomorrow night we will talk more. Yeah, guys, and if you guys have been spreading the word, I really appreciate it. Looks like there's a lot of new names I see, and that's always kind of neat. And, I appreciate you guys are willing to bring people around, and I appreciate you guys sticking around. So, yeah, I will see you guys tomorrow. Christy, I don't know and I apologize if you've been in before, but anyways, thanks for stopping by. Yeah, on the road to 1 million subs now. Yeah, Matthew, go to bed, dude. It's like 11 o'clock, man. Get some sleep in. Anyways, guys, have a nice night.